Hello, good evening. Hello, everybody. Good evening. Welcome, welcome. Hello. Hi there. Happy Friday. We made it. We made it to Friday. Yay. That's worth celebrating, I think. Yes, we did make it. We did make it. Woohoo. Yeah, it's been a busy week, everybody. It has been busy. So, whoo. Yes, yes. Hello. Oh, thank you. I think you've got a little Halloween vibe going on. I think it's time. So, I'm going to do one last check on the dockets here. Okay. Yeah, there's just been so much going on. Yes, yes. Halloween nails tonight. I know it's early, but I think that's okay. I'm okay being a little bit early. Oh my goodness, goodness. Yes, yes. Yes, oh my gosh, there's been so much going on. Hello from Michigan. Hello, welcome, welcome. Yes, yes, welcome back, everybody. Hi from Spain. Hello, welcome. Good to see you. It's been a very busy week. Very, very busy. I've got lots to go over tonight, so oh my goodness. Trying to stay on top of it, but not easy. Hello from Seattle. Hello, hello. Good to see everybody. Oh, yes, yes. Need a little extra bling today, so oh, yes. Welcome, welcome everybody. Good to see you. Yes, so there's been a lot going on this week. So I've got a couple updates on the New York case, and then I do plan to go through the motion to dismiss for the DC case, and then we will also go through the Giuliani petition. So, oh, Ontario, hello, welcome, welcome, welcome. Yes, I'm a little early today so I can have a chance to say hello to everyone and make sure we get everything all set up. So, yes, I did. I changed my nails from this morning. Yes, I'm not really a morning person, so, when I try to get myself sorted out in the morning, sometimes it doesn't turn out that well. So, I need a little more time and coffee in order to be alert. So yes, Cape Cod. Oh, hello, hello. Well, thank you so much, Jilly Bean. Oh, I'm so glad to see you. Always good to see you. Yes, so got your supplies of lollipops? Absolutely. I did actually go to the store so I could stock up a little bit. Yes, that's right. I'm not early. I'm just right on time, my own time. Hippity boppity boop. Oh my goodness. Oh my goodness. Yes, yes, yes. So it's Friday. Yes, I do have fun plans for this weekend. So this will kind of be my kickoff to a fun weekend. So I'm excited about it. Have some spicy popcorn tonight. Yes. Oh, I love that. Go for it. It's a spicy popcorn kind of week. It's been a lot. There's been a lot going on. Really, she just opened her own nail shop. Oh, I love to hear it. That's wonderful. Studying to be a teacher of English. Really, the Constitution. Yes, well, congratulations. Well done. Well done. Yes, yes. How many bottles of right for tonight's session? I don't know. Oh, that's a good question. I'm not sure. Can you talk about the pillow guy and his loss of his $300 million? Oh, yeah, it's unfortunate for him. But Yeah, Dominion's not playing around. They were pretty upset. So, oh, thank you so much. Yeah, Dominion filed the defamation lawsuit against multiple people, and they were asking for over $1 billion. So, as we all know, Fox settled their piece, but we've got most people still involved in the lawsuit with that. So they're still involved. Yes, and Cannon's on an indefinite pause. It seems like it. I do have a few orders that have been done out of Florida, but I think I'm feeling okay about Florida. I'm feeling like she's still, plugging along. So far, we'll see. We'll see what happens, but oh, love that 3D Halloween masks. Yes, yes. I think it's never too early to start celebrating. Her brain's on pause. So funny. Oh my goodness. Oh, yeah, he's back to the beginning. Oh my gosh. No, I've just started. Ooh, hot tamales. We love that. Oh my gosh. Yes, yes. Yeah, no, we've just started. We've just started. She granted a delay again. Yeah, so we had kind of a partial grant, and honestly, it's not too bad. It could have been a lot worse. So granting in part and denying in part the motion for access to the SIPA filings is actually not too bad. It's not too bad of a delay. Oh, thank you, Jen. Thank you. Yeah, it's not too bad, although it is still a delay. So we continue on with that trend in Florida. Florida does seem to kind of be a little bit behind on everything. But hello, Paralegal Life. Happy Friday. We made it. Woohoo! Oh, yes. I'm so happy we made it. Yes. I've got one of my favorite rings. Yep. Freshen up the nails. I'll probably have these on for the next few lives. So yes. Nope. I'm just getting us started tonight. I was able to hop on a little bit early tonight just to say hello to everybody. Yeah, 3-day weekend. Now, is Monday's Columbus Day? Is that right? I'm trying to remember. Do we still call it that, or we call it a different name now? I'm trying to keep up on it, but I'm kind of in my own world over here. So, but yeah, it's nice. It's nice to have that. Columbus Day. Okay. Yeah, I know the judge in Georgia was talking about that during the hearing yesterday. He's like, I think there's a holiday on Monday. And they're like, ooh, because he's ready to go. Indigenous Peoples Day. Right. Okay. We love that. Yeah, I wasn't sure exactly. Okay. Indigenous people. Yes. Wonderful. Yes. So Monday then is a holiday. Watch the hearing today. Ooh, sassy was the hearing from Georgia. Yeah, it was really interesting. It's a federal holiday. Okay, that's good. That's good to know. Yes, so we've got no school, I think, on Mondays. Is that right? For Columbus Day or Indigenous Peoples Day? I'm not sure. Not for school. Okay. Oh, yesterday's hearing. Yeah, I thought it was really interesting. Powell's attorney is pretty polished and pretty passionate, but I think he may have been I think he brought a little too much thunder, in my opinion. I think he should have kept a little thunder in reserve, but he did a good job. Yes, he really wasn't. Yeah, Christopher Columbus. Yeah, there were problems. That's just true. There were just problems. Yes. Oh, you don't get the day off. I think it just depends on where you're at. Yeah, I think some of the courthouses are just not closing either. Keep some of that thunder down under. Yeah, that's funny. True. Yeah, he brought a little too much thunder to the hearing. I thought yesterday the judge was not impressed. Only 17 states have it as a federal holiday. Okay. Very interesting. Yes. Okay. So we will have, hopefully, some of us will have a no mail. All right. The judge was really patient. He's very professional. I really like Judge McAfee out of Georgia. I think he is pretty good. Pretty good. You work in Texas? All right. Oh, yeah, that's a bummer. Some places are set, but some places are not. So if you are one of the lucky ones that gets Monday off, I'm excited for you. That's really nice. Oh my goodness. Yes, happy Friday. Oh, yes, thank you so much. Yes, so it's 6 o'clock, so I'll go ahead and get started tonight because I've got several things that I want to go over. I'll kind of start and finish with the New York civil case. So, as many of you probably have heard, right, for the New York civil case this week, we had 3 witnesses. Today was the third witness, and the third witness for the state today was Jeffrey McConey. Now, he is named as one of the defendants, and so he was deemed a hostile witness, which means the format of questioning for the Attorney General's office was that of cross-examination because he was deemed a hostile witness, but he was the accountant. Now, he has been given immunity, and the statute of limitations have run for any tax criminal charges, so he's not going to be charged criminally. So a lot of the information he testified to today had to do with taxes and this kind of intentional inflation and deflation of numbers and the effect it had on taxes. So his testimony was incredibly important today. So it was a key piece to the case. Yes, it was quite the info. Exactly. It was absolutely a key piece to this case. So again, we're at a point where we're determining what level of fines are appropriate. That's really what this case is about. A finding of fraud's already been found, but intent and those kinds of elements will determine what level of damages need to be awarded. So that's really the key. Oh, Thanksgiving in Canada. Well, happy Thanksgiving. Oh, that's wonderful. Yes, so he does not have tax issues. And so that was one thing we've been talking about is if criminally they were going to charge tax fraud. And I'm not sure if the statute of limitations, I think the statute may have run on multiple pieces. So I think that's another reason why. So we'll see what happens. Now, the other thing after this testimony that was pretty significant, the other thing that came out that we talked about was there's a notice of appeal, right? So we have the order on that motion for summary judgment that came out, and then Trump has appealed it. And so he asked the appellate court for a stay, meaning to pause the civil case until the decision was made on the motion for summary judgment, right? And then this morning I went through the judge's order where he had set out that Trump needs to show how they're winding down their businesses and have that information shown. So that was the most recent order. But this afternoon, the Court of Appeals has ruled on that stay, and they have denied it. So the trial will continue. But there were a couple of pieces that I think are really important to note for the Court of Appeals. Again, he appealed that motion for summary judgment. They've not decided on it yet, but they have said that the trial will continue on. Even though they haven't decided on the motion for summary judgment. But a couple of bits have been added here. So, especially regarding this cancellation of the business certificates of multiple entities, including non-parties, and 2, appointing an independent monitor to dissolve those entities. So those pieces are important. We do have that monitor coming in. But here, the appellate court is saying there's an asking here for a stay of the enforcement of that decision regarding dissolving those certificates and the order of summary judgment pending the appeal. So they have held here, we've got Supreme Court decisions, September 26th. So that was the ruling on the motion for summary judgment. And October 5th, those decisions imposing unauthorized, undemanded, overbroad relief without proper factual or legal predicate, which will result in significant irreparable harm to inter alia non-parties. Has the undertaking been posted? No. So in this, appellates file a writ of mandamus or mandamus on September 14th, seeking a stay of trial pending Supreme Court's compliance with the court's June decision. So what I think is most important to note is this extra piece that the Court of Appeals has added on. Defendant's application for an interim stay of enforcement of the Supreme Court's decision dated September 26th and October 4th and first day of trial is granted solely to the extent of staying enforcement of the Supreme Court's order, which is they call their trial court their Supreme Court order directing the cancellation of the business certificates. So the actual order that canceled those business certificates, that has been paused, and they're pausing it until they can review that order on the motion for summary judgment. Okay, is everyone following me? So the trial will continue on as it goes, but the appeal on the motion for summary judgment will also be put in front of the Court of Appeals, and they have a certain period of time in which they'll take a look at it. But while they're waiting for the appeal to be decided, the trial will continue, but the dissolution of the certificates will be paused. All right, so that's what this order does. I'm not sure what their docket looks like as far as when the appellate court will review that order on the motion for summary judgment. So I'm not really sure. I know the trial, again, is scheduled until December. So technically, they really have until December really to kind of make those decisions. So I'm not sure when the Court of Appeals will make the decision, but in the interim, the dissolution of the business certificates is to be paused. Yes, that's the end of the appeal. Yep, that's it. Yeah, they're pausing until the Court of Appeals digs into that order on the motion for summary judgment, right? So the judge has already ruled and has found fraud on cause 1. Now, Trump is appealing that order, and until the Court of Appeals review that order and make decisions, the trial will still continue on, but the dissolution of the business certificates will not occur. So they've paused that. He has access to the businesses still. Yes. He has access, but it just means he's not being pushed to dissolve the business certificates until that motion or until the order has been determined. All right, so the judge's order dissolving those certificates is being appealed. So the Court of Appeals is saying, until we decide this issue, you do not need to start the process of dissolving your business certificates. Now, to me, that makes sense. I think that legally that makes sense because I don't believe that he will win the appeal, but technically, until the appeal's decided, you don't want to start a process of dissolving certificates and then have the Court of Appeals come back and say the decision was wrong. You need to go back and try cause 1. You see what I'm saying? Yes, the monitor's still in place. Yep, the monitor's still in place. All of the other things are all in place. The only thing is that the actual directing of the cancellation of the business certificate. So the cancellation process is paused until the Court of Appeals decides whether to affirm or reverse the order. He can still move stuff around and shift money. So let's take a look again at the order that the judge set out. All right, we went through this order earlier today. Here where the judge set out multiple conditions. Okay, so for each section of the 130 entities, defendant shall provide and monitor with advance notice of all of these people, all of these different pieces. All right, so I don't see on the Court of Appeals order that anything in this order is denied. So all of these pieces, this is the October 5th decision. So to impose unauthorized, undemanded, overbroad relief, and so on, is still allowed. I agree. And then it says here, they're agreeing in part. So what has been done already is fine, except the one piece is the dissolving of the certificates. So that's my understanding of this order, is that they're saying all of the orders, everything is fine, but until we finish reviewing it, the dissolution is not to start. because again, he had ordered in his original order to start dissolving the licenses. So that's the only thing being put on pause. I don't know when the court will decide that. It'll depend on their docket, when they have a chance to go through the, oh, thank you so much. Thank you for the sweet presents. I appreciate that. Yeah, he will, they'll have to set their docket, and then whenever they're able to review the case. I mean, I'm sure that they're aware of how important it is to get the decision made. But all the appellate court is saying here is the trial can go on, but we do not need to dissolve the certificates right at this moment, okay? So we had that huge push to say, you need to dissolve immediately. The appellate court says, let's pause that. Everything else is in place, but we need to pause dissolving those certificates. Could he sign the companies or property to Melania? No, I don't believe so. Not according to the order that was October 4th. Now, again, if we go through here, the application for an interim stay of enforcement of the Supreme Court's decisions dated the 26th. So this was the order to dissolve the certificates, and October 4th, which set out those conditions regarding transferring and recertifying, right? I went through all of those elements earlier. So for these two orders, and for a stay of trial is granted solely to the extent of staying enforcement of the Supreme Court's order directing the cancellation of business certificates. So the only thing that's paused is the actual canceling of the certificates. All right, so let me show you again in case for anyone who wasn't with me this morning, I kind of did a bonus live this morning, but we had an order that came out of the court. Here it's received on the 5th, and what the order said was certain conditions that he put on. All right, so he said here that the party shall have until October 26th to provide the court with the names of potential receivers. That's still going. Ordered that within 7 days of the date of this order, defendants shall provide an independent monitor with a list of all entity defendants and all other entities controlled and beneficially owned by Donald Trump. That's still happening. All right, this is still required. It's further ordered that for each of the entities, defendants shall inform the monitor whether and to what extent any third party has an ownership, partnership, or membership interest in such entity. That's still good. Ordered the plaintiff shall assist in the monitor by confirming through access of the Department of State records the information provided by defendants regarding Section 130 entities. Again, that's still good. And ordering for each of the entities, the defendant shall provide the monitor with advance notice of, and then that goes into any applications for new business certificates in any jurisdiction, creations of new entities to hold or acquire the assets, any anticipated transfer of assets or liabilities, any anticipated distribution from any of these entities, any assignment of rights from Section 130, and any disclosures to third parties regarding the transfer or cancellation of business certificates. Also, any modifications to existing contracts or obligations all needs to be reported, and any notice by a counterparty declaring an event or default resulting from the September 26th order. So, the only thing that the Court of Appeals has paused is the actual dissolving of the certificates. Everything else in all of the other two in the orders is all still good. They still have to follow the rules. Right. They still have to follow the rules. It's just they do not have to have the certificates dissolved. Yes. Oh, hello, Lisa. Hello, welcome. So that's the update then on what's been going on in New York. So the trial will continue. Remember, there was this question, is the trial going to be paused until the Court of Appeals decides? No, it's not. The trial will go on. Everything will continue on. It's just they do not need to dissolve the certificates as quickly until after the Court of Appeals decides the case. All right? Hydrate. Oh, yes, thank you. The certificates will still be dissolved after the appeals. Exactly. Yep, exactly. It's just putting into place kind of an extra layer of protection just in case the Court of Appeals does decide to reverse anything in the judge's original order. So if anything does get reversed and they actually have to go to a full trial on the first cause of action, which they would do, that's the worst thing that would happen, would be if he's reversed, they would go back and they would have to put on a trial for that first cause of action instead of just causes of actions 2 through 7. All right, so cause 1 would have to be tried. That's the worst that would happen. I doubt it's going to happen. But because of that, they're saying, until we've decided the appeal, you do not need to dissolve the certificates because we want to make sure everything is done first. Yes. Yep, exactly. Okay, so what are certificates? So great question. Under Section 130 of the New York business law, you have to get permission in order to practice, or I guess not practice, but to do business in New York. All right. So you have to have a license. So these are essentially licenses to let you do business in New York. So this is the code section in New York that allows you to do that. So that's what they're talking about when they're saying the 130 entities. How does a state have anything to do with value if it doesn't pertain to taxes? Well, it does. It does pertain to taxes, but also that's because of how the law was written. So it's the specific law that was used to bring the lawsuit as well that actually gave jurisdiction specifically to the Attorney General. So that's what is under Section 63, subsection 12. So, and I think I saw it here. Here it is, right here. So this law, all right, this New York law allows for the Attorney General to bring a cause of action when there has been repeated fraud in business. That's how the law was written by the legislature in New York. Yep, they require the certificates to do business in New York. Yep, you got it. Okay, so is everybody up to date then? Everyone's following me there on the New York case. I want to make sure everyone's with me before I move on to our next topic. We've got a couple things for tonight, but did anyone have any last questions? Yes. Okay, got it. Great. Right. Business license. Yep. 20,000 feet. Oh my goodness. All right, excellent. Okay, everybody. So that will be it for the New York civil case for a while, because there's so much going on in the other cases that we can catch up with what's going on in the other cases. So we'll put the New York civil case to the side for a minute here. And I do want to remind everybody, let me just show you again the trial calendar for October here before I dive into DC. New York state of mind, exactly. So for October, we have finished out this week, and we've got DC pretrial motions that are not motions in limine due in DC on the 9th. We have the demurs being argued in Georgia for the next couple of days. We've got a couple of things that just came down in Florida. I'll probably go over those this weekend with everybody. The updates out of Florida. And then we have the New York criminal case going on the 10th. So just so everybody knows, I will be doing a live on the 10th of October, just focusing on the criminal case. So there's multiple counts going on here of business fraud, multiple felonies, all Class E felonies. So I'm putting together a presentation to just spend the 10th going through this criminal case, because I think a lot of people, this is my live calendar here, a lot of people I think have forgotten about this case. Yes, the Stormy Daniels case, it's still going. It is still going. There has been no resolution on Stormy Daniels. There was a motion to dismiss filed. The government has to file their response to that motion to dismiss on the 10th. Yep, this is the hush money case. And again, this is a huge case. I mean, it's over 30 felonies. So it's significant that a grand jury came down with that indictment way back in March. So I will be going on Tuesday. I will be spending the whole live just talking about the New York criminal case. Okay. So just kind of keeping that up to date so everyone knows where we're at. But what I will do then, again, this is my live calendar, which is coinciding here with the trial calendar. So what I will do, because we do have some updates, is I will set for tomorrow. I will go through and do a Florida update. I had planned to do Georgia, but I think with the new information that's just come out of Florida, moving a couple of things, I'll go ahead and do the Florida update tomorrow. And then if I've got time, we'll do Georgia, but we'll just see. Okay, so tomorrow I will go into the Florida update. And then probably flip and do Georgia then on Sunday. All right, so that's what's been going on there. And then we've got the gag order hearing the following week. So there's a lot going on. So the next thing, a weekly syllabus. Absolutely, you got it. You got it. When does he go to court in New York for the Cohen lawsuit? So he has dismissed that case. Now, I'm not surprised. We already had some huge issues in his defamation case against CNN. That was already dismissed. In his defamation case against Clinton, that was already dismissed. So all of his previous defamation suits have not gone well for him. So I'm not surprised that he chose to dismiss the Cohen case. He was scheduled, actually, Mr. Trump was scheduled to do a deposition for that case over the weekend. So I think it's interesting that he filed his motion to dismiss that case so that he didn't need to go in and do a deposition this weekend. I didn't realize that Trump was scheduled for that, but he was, but not anymore because he's dismissed the cases. Which does not surprise me again. He's had a hard time being successful on those cases. So, attorney's fees, yes. Yes, I would say so, absolutely. Addicted to your lives. Oh, well, I'm glad you could join me. He did that without prejudice, right. Right, and the big thing that he has said too was that he will reconsider it at a later time. You know, he's got a lot going on right now, and that makes a lot of sense. But also, if you look at CNN, if you look at Clinton, if you look at his other defamation cases, he's not having a lot of success on those cases. So again, I'm not surprised. I'm not surprised about that. All right. So that's kind of the general update. So for tonight, I have two things that I want to go through. We have a couple of updates. The first will be out of DC. He's got his motion to dismiss that he has filed. So I'll just take you through that. I probably won't go line by line because it's just not worth it. It's really just not worth it. But he did do a motion to dismiss. Then we have a reply supporting that motion for an extension of time. And then we have another reply for an extension of time to file the SIPA Section 5. And this is DC, all right? And then we have an opinion and an order granting in part and denying in part. So I'll take you through that process here in these different documents. The other parts of tonight, so this is his motion to dismiss, and I'll take you through this. Again, he's claiming presidential immunity, which is not a valid argument here, but we'll just take a look at it. And then the other document I wanted to go through tonight with everybody is the Giuliani lawsuit against Biden. So we do have a defamation lawsuit here. Giuliani has filed against Biden. It's pretty thin. It's thin. It's pretty thin, but I will take you through this. This won't take very much time, so I may actually start with Giuliani here. But I'll take you through that, and then we'll go through that motion to dismiss, and I'll update you on the DC situation, okay? So that's kind of just giving you a heads up for everybody. So let's go ahead and start with Giuliani, because this one shouldn't take too much time on this. Oh, you're welcome, everybody. I'm happy to. Thank you for joining me. I appreciate it. So let me make a little sticky note so everybody knows what we're talking about. I'll take you through this, but I've already kind of marked it up because I couldn't help myself. I just couldn't even help myself. It's awful. It's as bad as you are imagining it to be. It's not the best. All right, let me make my little sticky note here. Defamation against Biden. So, he has filed this, and it's pretty weak. It's pretty weak. Yeah. He filed it in New Hampshire, yes, because people watched the debate in New Hampshire, and he's claiming that two statements made during the debate were defamatory and hurt his practice by millions of dollars, and so that's what he's suing for. But it's a mess. This is a mess. Yes, shenanigans, I think, is an excellent way of saying it. I try to be as impartial as possible, but when I see poorly written complaints, I say what I say. I can't help myself. Oh, bologna sandwiches. Yes. All right, so here we go. Let's dive in. I'll start again with Giuliani, and he is suing. I think this is important to note. He actually screws up. He kind of messes up the parties a little bit on. Later on, I'll kind of show you. But so we have Joe Biden, of course. Then we have this campaign, Biden for President, the Biden Victory Fund, Biden Action Fund, Biden Fight Fund, and Biden Baldwin Victory Fund. So he's included 4 fundraising committees included in here as well, because he's claiming that they benefited from the defamatory statements, all right, by being able to raise money. So that's why these 4 other PACs or entities here are included along with Biden. It's shorter than Giuliani. It is. Oh my gosh, it really is. There's not much substance here, and I'll take you through. It's not a good example of a complaint either. It's just not very well written. All right, so here we go. So here's the complaint, which is what you file when you're going to sue someone, and then they have to file an answer and response. So he has requested a jury trial. He's bringing this action to recover damages for defamatory and false light statements made about the plaintiff by the defendant, President Biden, a private citizen, and on behalf of or in joint and severally encouragement, support, and sponsorship of the remaining defendants. So again, when we're talking about defendants, we're talking about these 4 funds on top of President Biden. All right. So he sets out who the parties are. So he is the injured party. Again, never mind my little scratches here. And then the defendant, and the defendant's address is 1600 Pennsylvania Avenue. This just shows you how ridiculous this is. So he's set out the defendant here. We have the defendant's campaign committees as well. So he lists each one of those out and sets out how much he came up with, I guess. He's got numbers for how much the committee had raised. So that's really what this first part is. So again, we've got street addresses for the different funds that were named as defendants. And he kind of messes this up a little bit because he includes other people that aren't actually included. But so we go through and he says, here we've got the Biden Victory Fund. Here's their ID. Here's their money. And we've got the Biden Victory Fund again. And here, this is how much money they have. And then we've got the Biden Action Fund. And that's included. They're set up in DC. Here's how much money apparently they raised. Then we've got the Action Fund as well. He's going in again to how much money they've raised. I believe he's setting out this amount to try to show that they benefited from these statements. Okay, so there's really not much to the beginning piece. We've got the Victory Fund here, address, how much money he's claiming again that they benefited. Then we have Biden for President Committee. Again, this just coincides with all of the funds that he listed as defendants. So setting that up. Now, upon information and belief, all organizational defendants are identified above. So he's just including them all in with President Biden. Then he goes into jurisdiction and venue, and again, we're in New Hampshire. So that's interesting, and he's claiming New Hampshire works because there were people in New Hampshire that saw the debates, so that's why he's saying there's jurisdiction. Yeah, it's a lot. When he's saying the elections were... Right, that's a great question. So here's a couple of interesting things. He's setting out the law here. He's saying the court's got personal jurisdiction over Biden because Biden committed tortious acts, so defamation, within the state as described later. Now, he's saying two things. By making defamatory or false light statements about the plaintiff in at least one media outlet in New Hampshire, and based upon experience and belief to multiple media outlets, or by making defamatory or false light statements about the plaintiff in such a manner and under such circumstances as he knew or should have known that those statements would be and were distributed, otherwise published. Again, because people saw the debate in New Hampshire, or both. He's setting out here personal jurisdiction does exist because they're jointly and separately encouraged and relied on. It's a stretch. Now, he's using here the application of the New Hampshire statute of limitations and the single publication rule. This is a special rule in New Hampshire where all it takes in New Hampshire is one publication in order to go forward with a defamation claim. All right. So he's citing this case in order to say that that's allowable. Also saying the plaintiff can recover for the distribution of each defamatory statement in the jurisdiction and not just in New Hampshire, but also other jurisdictions. Now, I'm not going to, hide the ball. The state of New Hampshire, this would be a case of first impression with the facts that he's presenting here. He's asking them to set precedent on their defamation law for this first use or one use publication. They have not decided to allow for this, so they have not permitted this kind of jurisdiction yet. So he's asking New Hampshire to create jurisdiction in this kind of a case. So he's asking them to set precedent. I highly doubt that they will. So I do not think this will even get, I think New Hampshire will probably dismiss it. Anti-SLAPP laws, that I don't know. But I'll get a little bit further into the law that I'm talking about later on. He sets out the facts first and then kind of, again, goes into this question of, we think New Hampshire should set precedent with this set of facts. So it's thin. It's pretty thin. Yeah, I know, facts. It's hard. Facts, where are those? Yeah, New Hampshire's educated. Heck yeah. All right. So here we go. Let's go through the facts. This is probably the most entertaining part. So we've got in 2020, Trump and the defendant were nominated candidates, right? And there was a debate on October 22nd. So this is the date of the incident, all right? So the debate had 63 million national television and other video viewers, and he's just citing where he's getting those numbers from. He's citing CNN. At the national debate and in conformity with Biden's established pattern and practice for stating fantastic falsehoods throughout his public career, such as adopting in a speech the early years and family history of a British Labour Party leader as defendant Biden's own, it's a lot. It's hard to get through this. Defendant Biden having alternatively claimed to have been raised in a synagogue, a black church, and a Puerto Rican community, and defendant Biden having made the false and defamatory statements that the Catholic Church has changed its position on abortion, all of which falsehoods and defamations were made to further the defendant's political career. So the reason he's bringing this up is so he can show that there's this pattern of falsehoods. Again, it's a lot. Oh, yep, sorry. It was right next to me. It could have jumped up and grabbed me. There we go. Including without limitations by bringing political contributions, such as those received by the organizations that he has named here. These false and defamatory statements by Biden likewise were made to further Biden's political career, including without limitation by bringing political contributions, such as those received by the organizations that he's named as defendants. Okay, so you can see why he listed them as defendants and how much they had raised, because he's saying he wants to go after them. That's where the money is. So let's get into the specific statement. Defendant Biden's false and defamatory statements concerning the plaintiffs started at the October 22nd debate with the statement that President Trump's, quote, buddy, Rudy Giuliani, he is being used as a Russian pawn. He's being fed information that is Russian. That is not true. Okay, and so he cited the video where President Biden said that. Demonstrating that these defamations were not merely one of the defendant Biden's spontaneous insults, devoid of facts and ill-considered, but rather that they were planned. Biden continued his lies and defamations about the plaintiff and Russia that evening. Approximately 48 minutes after that first defamatory statement, Biden spontaneously returned to defaming the plaintiff. He stated with regard to his now famously disproven manufactured claim that the abandoned laptop of defendant Biden's son contained Russian information. Quote, hey, look, there are 50 former national intelligence folks who said that what he is accusing me of is a Russian plant. Ugh. It's hard to even get the words out. Oh my goodness. Very least. And then we're continuing on. Oops, I flipped the wrong page. Sorry about that. So he's a Russian plant, and they said that this has all the characteristics. 4 or 5 former heads of the CIA, both parties, say what he is saying is a bunch of garbage. Nobody believes it except his and his good friend Rudy Giuliani. It doesn't even make sense. The statement doesn't even make sense. So maybe he wants to stay relevant? That's a good question. All right, so defendant Biden knew the preceding statement about the laptop and asserting that the plaintiff lied about the content of the laptop were untrue. Defendant Biden knew it was untrue because his then senior campaign advisor, Antony Blinked, just the prior week played the crucial role in the inception of the false letter concerning the laptop signed by 51 national intelligence officials. Antony Blinken was the impetus behind its distribution, thus enabling the defendant Blinken to, I think this is a incorrect typo, to lie about the laptop and defame the plaintiff. Defendant Biden also knew that his words would have their intended effect of marginalize and thereby discrediting the plaintiff. The preceding defamation falsely claimed and depicted the plaintiff to our nation as a liar. These defamations were totally without fact or truth. The plaintiff was never used as a Russian pawn. Okay. He has never been fed untrue information that was Russian, that he knew was false, and that he used while asserting or implying its truth. Oops, sticky note. Sorry, everybody. The Hunter Biden laptop contained no Russian information, but rather contained the accurate, depraved, and revealing entries of someone engaged in influence peddling, but also in the throes of this here, and thereby revealing conduct and actions that at the very least would have cost defendant Biden the 2020 presidential election if he had not lied about them and defamed the plaintiff in the process of doing so. I know the laptop's back, right? It just never goes away. It's always there. It just keeps coming back. Might be more. I know. Oh my goodness. These defamations were made with actual malice or knowledge, which is what's required under the law, by defendant Biden that was untrue. These defamations were made with reckless disregard of the truth by defendant Biden. The plaintiff has spent years in public and professional service and has built a positive reputation and career for over 50 years. Now, we're going to start getting into his resume at this point, which is very interesting. he's putting in these points, I'm assuming, to show that his reputation's been harmed. So he's going to take us through his personal history here. I hope you are all ready. I hope you're ready for it, okay? For over 50 years, the plaintiff has provided public and professional service for and on behalf of the American people that only can be regarded as historical. Never mind my note there, sorry. The plaintiff began his legal career as a law clerk to the United States District Court Judge Lloyd McMahon from 1968 to 1970. The plaintiff served in the publican positions as an assistant United States attorney, chief of narcotics division, chief of the public corruption division, and executive assistant United States attorney from 1970 to 1975. From 1975 to 1977, the plaintiff served as an associate deputy attorney general in the Department of Justice. From 1975 to 1981, the plaintiff was a partner in the New York law firm of Patterson, Belknap, Webb, and Tyler. The plaintiff served as an associate attorney general of the United States, third-ranking position in the U.S. Department of Justice under President Ronald Reagan from 1981 to 1983. The plaintiff served as the United States Attorney in the Southern District of New York from 1983 to 1989. He was disbarred. I know, right? Oh, my goodness gracious. All right. The plaintiff served as the 107th mayor of New York City from 1994 to 2001. The plaintiff served as law partner in 4 different law firms, ran a successful worldwide consulting business, has served as personal counsel to the United States of America. I mean, personal counsel? You mean to the president? I don't know. That might be a typo. Has served as personal counsel to the United States of America, has been responsible for the successful prosecutions of some of the most important cases in the last 100 years. He wrote a best-selling book called Leadership, currently has a daily and Sunday highly rated radio show on the WABC and a daily evening live cast. Okay. Number 52, the plaintiff has served as United States Associate Attorney General from 1981 to 1983. How are we all the way back to 1981 again? The plaintiff has served as United States District Prosecutor of the Southern District of New York from 1983 to 1989. Did we cut and paste? That's my question. Did we cut and paste accidentally? The plaintiff has served as the 107th mayor of the city of New York from 1994 to 2001, and his reputation was of such sterling and unimpeachable character as to have resulted in him being commonly referred to throughout the country as America's mayor. Okay. The plaintiff does many charitable events and hosts his own well-received podcast in New York City. The plaintiff has spent years in professional and public service and has built a very positive reputation. He has been respected as a lawyer and public servant. Okay. Under the circumstances and because of the widespread distribution of the remarks and the context of the statement, despite all the years of public service and honorable conduct of the plaintiff, he was substantially and irreparably harmed by these defamatory statements of the defendant Biden but limited to the following reasons. All right, so here we go. Let's see how he was harmed. Here we go. Oh my goodness. Yeah. All right. When the plaintiff was identified as a pawn, it implied that he is easily manipulated, lacks agency, or is merely a tool used by others for larger objectives, thereby publicly undermining the perception of the plaintiff's autonomy, decision-making capabilities, and significance. Further, by identifying the plaintiff as a pawn, it implied that he does not act of his own volition, thereby damaging and causing a loss of reputation, especially as the plaintiff may hold or now be denied positions that require credibility, trust, decision-making, and independence. This false and defamatory description and comparison of the plaintiff will lower the plaintiff's reputation among others, and in the current age of social media and online communications, Defendant Biden's false and defamatory statements and the derogatory terms he used to express his defamations quickly became viral and massively magnified the harm to the plaintiff's reputation. Okay? All right. Yeah, yeah. All right, we made it, everybody. We made it through the claims. So let's talk about the law. Let's talk about the law here. Yes. Is there a therapist? Oh my goodness, good question. Yeah, it's a lot. It's a lot, everybody. It's a lot. All right, here's count one. Defamation per se, all the defendants. So Biden and the 4 committees. Biden knew the above referenced statement was false or acted with reckless indifference to the truth when it published the statement. And then he's including everybody that are the defendants. The defamatory statements of defendant Biden and chargeable to remaining defendants constitutes defamation per se because it accused the plaintiff of conduct incompatible with the plaintiff's business, trade, position, or office. Again, he was disbarred. As a result of the defamatory statements, the plaintiff has suffered damages within the jurisdictional limits of the court. So that's the first one. Count 2, defamation per quad, all defendants. So he's incorporating those in again. So the statements of Biden and chargeable to the remaining defendants constitute defamation per quad based on extrinsic facts proving the existence of actual damages to the plaintiff's reputation and business. All right. Count 3, libel. The defamatory statements and chargeable of all of them were published as a broadcast and therefore constitutes libel. All right. And then count 4. Here we go. Invasion of privacy, false light. So the New Hampshire Supreme Court, this is the key. This is the key to this case. The New Hampshire Supreme Court has not yet addressed whether the tort of invasion of privacy, false light is recognized in New Hampshire. That's kind of important, everybody. That's kind of an important thing. If you are suing somebody under law that's not recognized by the state, that's kind of a big deal. All right? The court's choice not to do so at present was recently confirmed. So they even recently, in just June, said, no, this law doesn't apply in this state because of the parties to that appeal having not presented research and argument to the issue. So he's saying that the state of New Hampshire denied it because the lawyers in the case didn't argue it properly. Okay. Since 2002, however, federal courts with jurisdiction over New Hampshire have anticipated that the New Hampshire Supreme Court would recognize this tort because it's recognized by Section 652E of the Restatement of Torts, which is essentially like a dictionary, all right? And the New Hampshire Supreme Court looks to the restatement in developing the common law of New Hampshire. All right, so, yeah. I can't. I know, everybody. I can't. It's just, ugh. All right, here we go. The restatement describes the tort of publicly placing a person in the false light in the following way. And then he talks about the restatement, which is, again, irrelevant. And then next he comes up and he says, there's a book, right? There's a book called Torts, Section 112. And in this book, it says that this is an important law. Next, he says the false statement does not, however, need to be defamatory to be actionable, only offensive. Again, we have another book called The Law of Torts. So he's citing books and the restatement after already citing case law where they've rejected the law. The statement made by defendant Biden, which were chargeable to the remaining defendants, were false. The statements made by defendant Biden, which are chargeable to the remaining defendants, were highly offensive to a reasonable person. As a result of his statements, the plaintiff has suffered damages within the jurisdictional limits of the court. And so he names the defendant again. They jointly and separately encouraged, relied on, promoted, and or realized substantial sums of money from the statements that he made. So that was the key piece. He said they made money off of his statement about him being a Russian pawn. Yep. Yeah, I just don't. I mean, the law doesn't support the claim. And yeah, I mean, I'm wondering if he wrote it himself. I think it's possible he wrote it himself, but all right. So here's what he's requesting. Wherefore, the plaintiff, Giuliani, respectfully requests that the court enter judgment against the defendants on all counts, which would involve them reversing their opinion that they've already held that the law doesn't apply. Enter judgment against the defendant representing all of the following damages. Actual losses, so this is what he's asking for money. We don't necessarily give dollar amounts. We ask types of damages. Presumed losses, so what he thinks he lost because of it versus his actual. And punitive damages. So punitive damages are damages awarded as a punishment to the defendant for bad behavior. An example would be the McDonald's coffee case. The damages awarded there were punitive damages because McDonald's was being a jerk about it. Punitive damages to punish and deter the egregious defamation by defendant Biden. All right, so these are the damages he's asking for. Hydrate, yes. Yes, I do need to hydrate. Oh my goodness. Coffee, it's hot. That's true. Actually, I'm going to pause just for one moment. The McDonald's case really gets me going here. Let me just take a moment. So, real quick, McDonald's was told that their coffee was not fit for human consumption. They were told that repeatedly, and they said, that's okay, we'll just pay hospital bills. So when this woman got third-degree burns on her most sensitive areas and was put in the hospital, they refused to pay her medical bills. So she said, I'm going to sue you. And they said, fine, we don't care. So they went in and they showed the coffee was not fit for human consumption because of the temperature they were serving it at, that it wasn't, humans should not be consuming it. All right. So they went to trial. Of course, they found for McDonald's. Now, the judgment, right, that the jury gave, the millions of dollars, was actually reversed by the judge. The judge actually only awarded medical expenses and attorney's fees. So that huge multi-million-dollar winning award in the McDonald's case was not actually awarded. And again, it was because the coffee was not fit for human consumption. So they turned down the temperature of the coffee for a few years, and then they turned it back up. Yep, so there you go. There's a McDonald's case. Yep, she got her medical bills. She's an amazing woman. She was an incredible woman. She was just this strong lady who was like, you dingleberries, what are you doing? Yeah, I mean, she was in the hospital for a really long time. Yeah, so interesting side note. Not fit for human consumption. That's kind of a big deal. And they knew it. All right, anyway, I digress. So that's what punitive damages are, though. Huge amounts in order to punish. So he's also asking that Biden publicly acknowledge the falsehood of his defamatory statements, order the defendant to publicly acknowledge the falsehood of his offensive statements. So we've got defamatory and then offensive. Order remaining organizations to disgorge and pay to the plaintiff their illicit gains, meaning he wants all of the committees that raised money to give him all of the money that they raised. Yep. Because of the statements that were made, enter a judgment against the remaining organizations to pay damages as outlined in Request B and grant such other further relief that justice and equity should require. Yep. So there you have it. There's the Giuliani case for defamation. It's tough. You know, at first I was like, well, this is, whatever. Everybody can bring their suit if they feel there's grounds when it comes to defamation. But then when you get further into it and you see that the law he's using is not accepted in New Hampshire, that's when he lost me. That's when I was like, oh my gosh, are you kidding me? Are you kidding me? He spelled his own name wrong, did he? Oh my gosh, he did. Oh my gosh. Right. Yeah, it's a lot. It's a lot. Yeah, he's got it on here. Yep. It's a lot. It's a lot. Top of the last page. Yep. Right here. Giuliania. Oh, Giuliania. He He wrote it with a potato. Oh my gosh. Well, it seems, I would imagine, I don't think he has counsel. I don't think he has attorneys right now. Why New Hampshire? Yeah, it's a great question. Maybe because he wants to kind of argue this case of first impression with this false light statements business. That's all I can think of. That's the only thing I can think of, because every state, saw the debate. So he could have brought it in any state. So maybe he thought New Hampshire was the only state he could, try to get away with it. I don't know. It's a lot. He is an attorney, but he's not licensed at the moment. Yeah, I think your own name, like I misspell stuff all the time, but I think your own name's kind of a big deal. I think you're right with that. Yeah. He's doing it pro se. Yep. No license, no attorney. Yeah, I mean, you can represent yourself. You don't have to have a license to file a complaint, but it's a lot. Yeah. It's a lot. It's a lot. It's a lot. Yeah, I think his name's going to be known for a lot of other reasons. All right, so let's get into, let me make sure here that I'm centered okay. But let's go ahead and, it's bananas. Let's go ahead then and get into this motion to dismiss. This is also, banana worthy. He lost his license for unethical behavior. Yeah, he was disbarred. He was disbarred in New York and in DC this year. I'm not exactly sure of the dates. Yep. So now we can get then into this presidential immunity. Yes, I will go into that here as we kind of talk about this. So presidential immunity, I've got a lot to say about it. This is an area that, we study in constitutional law. It's really important. I think it's very important for everyone to know. So let's talk about it. First of all, this is the DC case, all right? So this is the interference with the official government proceeding, which was the electors in Congress. So that's what this is. Is there such a thing as presidential immunity? There is some presidential immunity, but it's very limited. And it's limited by a case called U.S. v. Nixon and Clinton v. Jones. Those cases limited the level of immunity. And even there's a case that was just decided, a Trump case regarding the search warrant for Mar-a-Lago. That case came in as well and limited presidential immunity. So there's limits on it. Fitzgerald was in place, but before the Clinton case. So Fitzgerald was before Clinton v. Jones. So Clinton v. Jones essentially kind of pushed the Fitzgerald case to the side. So it doesn't have the same impact. All right. So this is the DC case. Motion to dismiss. So let me just make my sticky note here. Motion to dismiss by Trump. All right. Yeah, it didn't. It really didn't. Yep. Yeah, we'll get into it. I mean, it's not going to work. I would say this would be considered a frivolous motion, but, they are filing these all over the place. It's kind of tradition, I think, for this set of attorneys. So we'll kind of get into that. I'll just kind of take you through it. I won't read it, but I'll just kind of take you through the format here. All right. So motion to dismiss the indictment based on presidential immunity. Let's see what he has to say here. Again, keep in mind, I think 3 of his cases have motions to dismiss active in them right now. So just keep that in mind as we go through. Yeah, it's a lot of stalling. It's a lot of stalling. It sounds like a song that never ends. It really is. All right, so here's our table of contents outlining his arguments here. President Trump moves to dismiss the indictment in this matter with prejudice based on presidential immunity. In support, he states the following. Allegations in the indictment. So he's talking about public statements and tweets about the federal election and certification, communications with the U.S. Department of Justice about investigating election crimes, and the possibility or possibly appointing a new acting attorney general. Remember that piece in the indictment where for a little period of time there we had alternative attorney general, and everybody said they were going to go ahead and resign. Communications with state officials about the federal election and the exercise of their official duties with respect to the election. Communications with the vice president and members of Congress about the exercise of their official duties in the election certification proceedings. Organizing slates of electors as part of the attempt to convince legislators not to certify the election against defendants. All right, so I'm going to be taking some time on a couple of these just to put out probably a preview of what his defense is going to be in his case. Yep. Here's the argument. Number one, the president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibility. The doctrine of separation of powers and the president's unique role in our constitutional structure require immunity from criminal prosecution. That's not true. Impeachment and conviction by the Senate provide the exclusive method for proceeding against a president for crimes in office. That's also not true. Early authorities support presidential immunity from criminal prosecution. Also not true. 234 years of history and tradition support presidential immunity from criminal prosecution. Well, not according to Richard Nixon. And analogous immunity doctrines support presidential immunity from criminal prosecution. Not true. Concerns for public policy favor the president's immunity from prosecution. And the indictment alleges only acts committed within the outer perimeter of the president's official responsibilities, which were shielded by absolute immunity. All right. The scope of criminal immunity includes all actions that fall within the outer perimeter of the president's official duties. The nature of the act, not the manner in which it is conducted or its alleged purpose, determines whether it falls within the scope of immunity. Every act alleged in the indictment falls within the outer perimeter of the president's official duties and is immune from criminal prosecution. All right, so that's the introduction here. So let's see. And I think, again, this is going to be his defense that he will be putting on in D.C. So we're getting kind of a preview of what he will be doing once that jury gets called and we're in D.C. for trial. All right, so here's a statement of authorities. Here, other authorities, statutes, Constitution. Yeah. So, again, I won't go through every single thing, but there is some really good information in here regarding how the law does not work. So I think that's important to note. So President Trump moves to dismiss the indictment in this matter with prejudice based on presidential immunity. First, introduction. The President of the United States sits at the heart of our system of government. He is our nation's leader, our head of state, our head of government. As such, the founders tasked the President and the President alone with the sacred obligation of taking care of the laws to be faithfully executed. To ensure the President may serve unhesitatingly without fear that his political opponents may one day prosecute him for decisions they dislike, the law provides absolute immunity for acts within the outer perimeter of the President's official responsibility. Okay, and they're citing the Nixon case. All right, Nixon v. Fitzgerald. So keep in mind the Nixon versus Fitzgerald case has to do with federal employees, and it was a different situation. It was in 1982. This case was before Clinton v. Jones, which also talks about presidential immunity. All right, so they're using this case to argue presidential immunity, but they're relying on the wrong law. And so we will see that repeatedly. We will see them relying on the wrong law a lot. All right, so here we go. Breaking 234 years of precedent, the incumbent administration has charged, that's not true, President Trump for acts that lie not just within the outer perimeter, but at the heart of his official responsibilities as president. In doing so, the prosecution does not and cannot argue that President Trump's effort to ensure election integrity and to advocate for the same were outside the scope of his duties. Instead, the prosecution falsely claims that President Trump's motives were impure and that he purportedly knew that the widespread reports of fraud and election irregularities were untrue, but sought to address them anyway. But as the Constitution, the Supreme Court, and hundreds of years of history and tradition all make clear, the president's motivations are not for the prosecution or this court to decide. Ooh, what do you mean for this court to decide? Hold on. So the president's motivations are outside of the courts? Hold on. I got to get my red pen going on this one. Here we go. That's questionable. Rather, whereas here the president's actions are within the ambit of his office, he is absolutely immune from prosecution. This is the Spalding v. Villas case. Note the year, all right, prior to Richard Nixon, right? He is exhausting. I agree. So we're citing more case law that is not relevant here. Let's take a look, see what he's got, see what else he's got here. We've got another case, the Midland case. Dismissal of the indictment is a proper sanction when a defendant has been granted immunity from prosecution. Again, this is not in reference to a president, though, so I don't think that that's necessarily relevant. Legal standard, in ruling on a motion to dismiss for failure to state an offense, a district court, and then this is the standard for a motion to dismiss, so I won't take time on that. Let's get into the allegations in the indictment here. Make it make sense. Make it stop. I wish I could. I wish I could make it stop, but I cannot. Alas, I cannot. Sorry about that. So we've got allegations in the indictment. President Trump, the incumbent administration's leading opponent in the upcoming presidential election, emphatically denies the truth of any allegations in the indictment. Rather, this memorandum sets forth the facts alleged in the indictment so that their legal sufficiency may be addressed for a motion to dismiss. Moreover, again, he's idding. He's idding what? Let's just double check. What's his id? Is he quoting the Weeks case? Wait a minute. Hold on. I forgot. He's quoting Weeks. I'm not sure why he's idding that case, but all right. I don't know. Moreover, the Supreme Court has repeatedly stressed the importance of resolving immunity questions at the earliest possible stage in litigation. That's true. Accordingly, this motion addresses only the question of presidential immunity. We're enjoying your company in the chaos. Oh, that's so sweet. I'm thankful for your company as well, because I would just be pulling my hair out by myself. Oh, my goodness. All right. Other fatal deficiencies in the indictment will be addressed in future motions and proceedings. All right. So let's kind of skip through. Let's see what he's got to say here. So far, I'm not impressed. All right. The indictment alleges President Trump took a series of actions that form the basis of its charges. Now, let me just remind everybody of what those charges are. All right. So if nothing else, we can be reminded about what the DC case is actually about, right? We can still learn. There's still learning that can happen here. Okay, so here's the indictment out of DC. We've got 4 counts. Conspiracy to defraud the United States, that's the fake electors. Conspiracy to obstruct an official proceeding, so that's calling a rally and having them go to Congress when they're trying to certify the electors. Obstruction of an attempt to obstruct an official proceeding, again, calling people and then having them interrupt Congress. Count 4 is conspiracy against rights, and the right would be the right to vote because of the fake electors. All right, so these are what have been charged. These are the 4 counts. The key here are the fake electors, right? The defrauding. We've got all the evidence of the letters and certificates. Also, the obstruction of the proceeding where Congress had to pause while they were invaded and then restart hours later. And then we have this issue of this attempt to kind of persuade or change what the actual voting results were. All right, so that's a breakdown here. So back to his motion to dismiss. All right, so he's saying that his actions did not form any basis for the charges. The acts fall into 5 basic categories. The indictment alleges President Trump, while he was still president, made public statements about administration of the federal election, posted tweets about the administration of the federal election. 2, communicated with senior Department of Justice officials about investigating this and about choosing the leadership of the DOJ. 3, communicated with state officials about the administration of this and the exercise of their official duties. By the way, number 3 is what he's charged with in Georgia, just so that we remember that. 4, communicated with the vice president in his legislative capacity as president of the Senate and with other members of Congress about the exercise of their official duties regarding the election certification. And 5, authorized or directed others to organize contingent slates of electors, which is not a thing. Okay, that's not a thing. In furtherance of his attempts to convince the vice president, again, you're not supposed to be convincing the vice president, that's not a thing either, to exercise his official authority in a manner advocated for by President Trump. Oh my gosh. Oh my goodness. Oh my gosh, that's a lot. That's a lot. All right, let's bump down. Again, my red pen is out and I'm not afraid to use it, everybody. Yeah, that's not a thing. I don't know who wrote this, but I'm already not impressed. Oh my goodness. All right, let's bump down our endnote here. In certain cases, the indictment does not specify whether President Trump had direct involvement in many of these actions or even knew they were occurring. But even assuming that he did, the acts alleged are all still of a public character. Isn't he admitting the crime? Yes, he is. Yes, he's admitting the crime right here. This is an admission of that particular piece of the crime. Oh my gosh. Yes, he did. Yes, he did. So he's saying let's go back. Let's take a look at it. He communicated with state officials about the administration of the federal election and their exercise of official duties. That is what he's been charged with in Georgia, and he just said he did it. Right. Yes, he's saying he did it. Now, he's also saying it wasn't illegal, which is what he's saying in all of his cases. He said the same thing in New York. Well, yes, I did inflate by $250 billion, but that's fine. It's repeated quite a bit. All right, here we go. Public statements and tweets about the federal election and certification. First, the indictment alleges that President Trump, while he was still president, made public statements about the administration of this. And then he's just going into each state. Arizona, Georgia, Michigan. And he's just quoting the different states. Wisconsin, Philadelphia. So he's saying about these different things. And then public statements in a speech about the scope of the vice president's authority. Statements in a public speech about January 6th and the scope of the VP's authority as well. Closely related to the allegations of public statements, the indictment alleges President Trump posted a series of tweets about the administration of this and its certification. And again, he's quoting the tweet. Criticizing Pennsylvania legislators, urging Americans to protest this, and regarding the vice president's authority as well. So he's quoting his own tweets here of the scope of the president and so on. All right, that's all that's included here. Next. So hold on here. Let's just pause for a minute. So wait a minute. Oh, yeah. Okay. Yep. Ugh. It's a lot, everybody. Okay, here's B. Can Georgia use this as evidence? Absolutely. Absolutely, they can. Yep, absolutely. Yeah, I mean, that's what he just said. He specified he specifically put it out and said, I was communicating with state officials. So again, I'm not sure what his defense is going to be in Georgia. Actually, if you look at the RICO acts, also the slates of electors is included as one of the overt acts. Talking to the vice president is included as overt acts. So technically, all these pieces right here that he said he did would be enough to prove enough overt acts in Georgia to satisfy the RICO charge. Yep. All right. The communication with the United States Department of Justice about investigating and possibly appointing a new acting attorney general. Now, I'm interested to see what he's going to say about this, his justification here. Remember, this is when the actual attorney general said, I'm not sure that you really want to do this. All right. The indictment alleges that President Trump attempted to use the power and authority of the Justice Department to conduct investigations and to send a letter to the targeted states from the Justice Department that claimed that the Justice Department had identified significant concerns that may have impacted the election outcome. All right, so everybody remember that? There was that letter. We had multiple memos discussed as well as the letter. The indictment alleges a series of meetings and communications between President Trump and others, including senior officials in the U.S. Department of Justice, relating to the investigation of federal this and possibly appointing a new acting attorney general of the United States, which, as the indictment states, President Trump ultimately did not do. Let's pause for a moment. Does everybody remember that meeting that occurred at the White House, that big hostile meeting that was involved? I did post a clip of that during the January 6th investigation in Congress. Yep. Okay. Yep. So, and then he's citing the indictment here, alleging a meeting with incoming acting attorney general, acting deputy attorney general to discuss allegations, phone call with acting attorney general and acting deputy attorney general to urge them to investigate election this, communication with the attorney general about this in Michigan, 2 communications with the acting attorney general and acting deputy attorney general to urge them about Pennsylvania, communication again about Wisconsin, meetings and communications again to investigate, attempting to convince the Department of Justice to send a letter to state officials expressing concerns. So he's listing out all of the pieces of evidence set out in the indictment. All right, Oval Office meeting here with the acting attorney general and deputy and other advisors, a meeting with the DOJ official in the White House. So I'm just skimming through this so we can see what his rationale is. The White House counsel, deputy House counsel. Oh, thank you. Thank you for that. So I guess he's just summarizing here all of his meetings and quoting the indictment. Next, communications with state officials about the federal election and exercise of their official duties. Again, all he's doing is quoting what is set out in the actual indictment. All right, so we've got just quotes of language in the indictment. So I won't reread through all of that because this, again, is just all language in the indictment. Yeah, these are the crimes I did. Oh my goodness. Communications with the vice president. So again, he's listing out specifically his actions towards the vice president. So just so that we know here, he's listing all of these out. He couldn't, because he was too busy. Yeah, he was too busy criming in other places. Oh my goodness. Okay, so I'm just circling this because these are just direct quotes out of the indictment. All right. So again, talking with the vice president, the phone call to the vice president, hand-delivered documents to the vice president regarding contingent slates of electors, which again isn't a thing. Okay, in addition to communications, the indictment alleges a handful of communications and attempted communications with members of Congress regarding their official authority. Again, we're citing the indictment again. All right, so E, organizing slates of electors as part of the attempt to convince legislatures not to certify the election against defendant. So this should be interesting. Organizing slates of electors, all right? In an attempt to convince legislators not to certify the election. Oh my gosh, that is an admission right there. Closely related to these communications, with the vice president, the members of Congress, an indictment alleges that other individuals organized slates of contingent electors for several states to provide a justification for the vice president to exercise his official duties in the manner favored by President Trump. All right, we're quoting the indictment again. So they're quoting specifically right out of the indictment again. The indictment alleges that Trump knew these actions, organizing the slates of electors, and directed them to continue, but it does not allege President Trump took any particular action in organizing them. All right, so this is one piece of their defense already. So let's back up just one moment. According to the indictment, these contingent slates of electors allowed President Trump in his communications with Vice President to justify the exercise of the Vice President's authority to certify the election in President Trump's favor or delay its certification. All right, so these are direct quotes. This is the only piece that I see that he's actually added his own language to. Here's the argument. So now we've all walked down memory lane to talk about the different pieces of that indictment with multiple admissions, which is fine. But let's see what the arguments are. What is his rationale that allows him to say that none of the things he did were wrong, and in fact that the case should be dismissed? Let's see what he's got to say about it. Here we go. The president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibility. In view of the special nature of the president's constitutional office and functions, a current or former president has absolute presidential immunity from civil damages liability acts within the outer perimeter. Again, we're quoting Fitzgerald, which again is not, No court has addressed whether such presidential immunity includes immunity from criminal prosecution for the president's official acts. The question remains a serious and unsettled question of law. Not according to U.S. v. Nixon. Let's just make a note here. I think his attorneys could probably read that case. It might help them. Holding in light, I'm not even going to quote this because it's not relevant. In addressing this question, the court should consider the Constitution's text, structure, and original meaning, historical practice, the court's precedents and immunity doctrines, and considerations of public policy. All right, I see what he's doing here. So he's asking the court to set precedent here by saying that he does have immunity. So he's actually asking the court to confirm this immunity that he's claiming he has, which has already been established by law. So it doesn't need to be established. It already has been. But that's what he's asking them to do right now. The doctrine of separation of powers and the president's unique role in our constitutional structure require immunity from criminal prosecution. So is he arguing to overturn Nixon? Is that what he's saying? That's interesting. All right. All right. Again, this is more of the Fitzgerald case here. Due to the unique status, structure of separation of powers. So again, he's really relying on this Nixon case. I'm not sure what it is about his attorneys pulling the wrong law, but it is just pervasive. It is pervasive, and it's like fingernails on a chalkboard. I don't know if anybody remembers what a chalkboard is, but that's what it's like as an attorney when you see them using the law incorrectly. Sarcasm emoji, yes. Use the sarcasm. Use the sarcasm. Yep, it makes me insane. I know. It's driving me bonkers. Is it malpractice? I don't know if it's malpractice, but this is the shenanigans that the judge was talking about in New York. When you file legal arguments, you cite case law incorrectly, you use legal arguments that are completely invalid. That's what we would consider bad faith and frivolous arguments. And that's what's going on here. I mean, this is just basic con law 101. Are you trying to completely rewrite 200 years of history? Meanwhile, they're saying if you don't follow us from this Fitzgerald case, then you are reversing history, which is completely incorrect. Can't afford a Westlaw subscription. All right. So again, we're going through this analysis of Fitzgerald. I'm not going to spend too much time on Fitzgerald because again, that is not the law that's relevant here. If they go through this entire brief and they don't cite Clinton v. Jones, I'm going to be extremely disappointed, I guess, is what I'm trying to say at this moment. All right, although Fitzgerald concerns civil liability, the exact same, if not more elevated concerns apply to potential criminal prosecutions, which again is in the Nixon case. Oh, I see Nixon just popped up. So let's see what's their analysis for Nixon. I'm very interested to see how they're putting those together. All right. Vertical and horizontal separation of powers simply cannot permit local, state, or subsequent federal officials to constrain the president's exercise of executive judgment through threats of criminal prosecution. To hold otherwise would be to allow the president's political opponents to usurp his or her constitutional role, fundamentally impairing our system of government. For this very reason, Fitzgerald recognized that presidential immunity is not just a creature of common law, but also rooted in the separation of powers under the Constitution. Quoting Nixon. What? He's just quoting Nixon? What? What? Oh my goodness. Oh my goodness. This is awful. This is awful. All right. Okay, I need a moment to collect myself. Oh my gosh, this is awful. All right, everybody, let me remind you real quick what the Nixon case was about, all right? So Nixon was actually president at the time that the whole situation with Watergate broke out, all right? He had already won the presidency, so he was the sitting president. And the question was, could they pursue criminal charges against a sitting president? And the answer was unanimously, yes, indeed they can. Okay, that was the answer. That's how it went. Summation of the Fitz law, just to validate your comments. Okay, sure. Yeah, let me just, I have been meaning to actually do a full video on the Fitzgerald case, but I find it so frustrating. So hold on just one moment. All right, so let me summarize here. I will use Oyez. If you go to oye.com, all right, so let me write this out as I'm saying it. Let me find a sticky note. Where did it go? Hold on. Here we go. If you go to oye.com or .org, you can actually pull up the case, oye.org, and you can listen to them arguing the case. So I've actually listened to the original oral arguments. All right, so this is the Nixon v. Fitzgerald case. And the citation is 457 U.S. 731, and it was decided in 1982. All right, so let me give you a summary here of it. Yeah, let me do a quick summary. All right, so the facts of the case. In 1968, Fitzgerald, then a civilian analyst with the United States Air Force, testified before a congressional committee about the inefficiencies and cost overruns in the production of the C-5A transport plane. Roughly 1 year later, he was fired, an action for which President Nixon took responsibility. Fitzgerald then sued Nixon for damages after the Civil Service Commission concluded that his dismissal was unjust. So this was a lawsuit against Nixon for an unlawful firing. All right? The question was the president immune from prosecution in a civil suit? The answer was yes. The court held the president is entitled to absolute immunity from damages, liability predicated on his official acts. This sweeping immunity, argued Justice Powell, was a function under the president's unique office rooted in the constitutional tradition of separation of powers and supported by our history. So that's Nixon v. Fitzgerald. let me read you real quick the holding in Clinton v. Jones. All right, so let me pull that one up real quick. All right, again, this is at Oye. You can also listen to the oral arguments, and the opinion itself was actually delivered. This case was decided in 1997, which means it is more recent than Nixon v. Fitzgerald. Okay, so whichever case is the most current is the one that holds the precedent. So this is Clinton v. Jones. I will just read you, it's only a few sentences. Paula Jones sued President Bill Clinton. She alleged that while she was in the Arkansas state employee, she suffered several abhorrent sexual advances from the Arkansas governor. Jones claimed that her continued rejections of his advances ultimately resulted in punishment by her state supervisors, following a district court's grant of Clinton's request that all matters relating to the suit be suspended, pending a ruling on his prior request to have the suit dismissed on grounds of presidential immunity. So he used the Fitzgerald case as a way to get his case dismissed, okay? So Clinton's immunity request, so here we go. On the grounds of presidential immunity, Clinton sought to invoke his immunity to completely dismiss the Jones suit against him. While the district judge denied Clinton's immunity request, the judge ordered the stay of any trial in the matter until Clinton's presidency, until after the presidency. On appeal, the Eighth Circuit affirmed the dismissal denial, but reversed the trial deferment ruling, since it would be a functional equivalent to an unlawful grant of temporary presidential immunity. The question before the Supreme Court is a serving president for separation of power reasons entitled to absolute immunity from civil litigation arising out of the events which transpired prior to his taking office. Conclusion, no. Unanimous opinion, no. The Constitution does not grant a sitting president immunity from civil litigation, except under highly unusual circumstances. Okay? All right? I'm extremely passionate about this. It drives me bonkers when people cite the Nixon v. Fitzgerald case without acknowledging Clinton v. Jones overruled this blanket presidential immunity theory set out in the Fitzgerald case. Boop, boop. Poor Ben. Oh, sorry, everybody. Sorry about that moment. It took me a moment. So his entire motion to dismiss is based off of case law that was overruled by Clinton v. Jones. And it was civil, exactly. And it was a wrongful termination, essentially. It was a very similar set of facts. Yep. You need water. Okay. Oh, my goodness. Oh, my gosh. This whole Fitzgerald situation, I tell you, ugh. All right. Okay. Get your rants out. Yes. All right. Okay, so everybody, now do you see why I'm getting so frustrated about this argument here? Right? Tonight's nail color. Has a judge in this case demonstrated the same kind of response as in the New York civil case? So this is Judge Chutkin. All right. She so far has done a pretty good job of saying, you know, I'm not going to have any bologna sandwiches in my courtroom, but we have the government's motion for a protective order for certain speech for witnesses and so on. That's going to be in front of her, argued in front of her, not this next week, but the following week. All right, so that hearing has not happened yet. Please read the footnote. Okay. To be sure, Fitzgerald did not decide whether presidential immunity extends to criminal prosecution and acknowledged that there's a lesser public interest in actions for civil damages than in criminal prosecutions. But the fact that the doctrine of presidential immunity is rooted in the separation of powers dictates that immunity must extend to criminal prosecution as well as civil liability. While the public interest in criminal prosecutions may be important, it's not important enough to justify abrogating the separation of powers, the most fundamental structural feature of our constitutional system.
Further, exposure to criminal prosecution poses a far greater threat than the prospect of civil lawsuits to the president's maximum ability to deal fearlessly and impartially with the duties of his office, and thus it raises an even greater risk to the effective functioning of government. Right. Yes? So I've read it. I've read it. I mean, it just even says it, I don't, yeah. Okay, Fitzgerald's reasoning, therefore, entails that the presidential immunity include immunity from both civil suit and criminal prosecutions. All right, so let's do one more. Let's do one more case citation here, everybody. Okay. Oh, my goodness. I just get so excited about constitutional law, everybody. I just can't help myself. So here we go. One more case, everybody. Now, if you really want to listen to a fascinating case where the justices are not playing around with their questions, what you want to do is go to oia.org and you can listen to the original oral arguments of U.S. v. Nixon. All right. Now, these justices are mad about what happened here with Nixon, and they do not hide their anger about it. So if you want to hear some frustrated justices, you can actually listen to the original oral arguments. So let me tell you the holding in this case, okay? Oh. All right, a grand jury returned indictments against 7 of President Richard Nixon's closest aides in the Watergate affair. A special prosecutor was appointed by Nixon, and the defendants sought audio tapes. The question was, is the president's right to safeguard certain information using his executive privilege, confidentiality power, entirely immune from judicial review? Conclusion, no. The court held that neither the doctrine of separation of powers nor the generalized need for confidentiality of high-level communication without more can sustain an absolute unqualified presidential privilege. The court granted that there was a limited executive privilege in areas of military or diplomatic affairs, but gave preference to the fundamental demands of due process of law in the fair administration of justice. Therefore, the president must obey the subpoena and produce the tapes and documents. All right? So Nixon is the case that is for criminal cases, presidential immunity. Fitzgerald involves a civil case. Clinton v. Jones involves a civil case. Presidential immunity in criminal cases was decided by U.S. v. Nixon. Now, I know it's a fun, interesting discussion about how this law is being twisted around in a weird way. All right. It's just, maybe fun isn't the right word. maybe fun isn't correct, but, all right. So now the last one, I won't spend much time on this, but I'll just give you a citation on this. All right. So if you're wondering where the U.S. Supreme Court is sitting right now regarding presidential immunity, the case that you want to look up is Trump v. Vance. This case was decided in 2020. So the citation is 2020 here. And the question before the U.S. Supreme Court in 2020, does the Constitution permit a county prosecutor to subpoena a third-party custodian for the financial and tax records of a sitting president over which the president has no claim of executive privilege? The conclusion, Article 2 of the Supremacy Clause neither categorically precludes nor requires heightened standards for the issuance of a state criminal subpoena to a sitting president. So this U.S. Supreme Court has said there is no protection for a sitting president when it comes to subpoena or criminal prosecutions. All right? Okay, woohoo! Oh, we got it. Yeah, I'll take you to the last page. I'll take you to the last page. Oh my gosh, I get so frustrated. Sorry about that, everybody. Hold on. Let me show you who signed it. All right, here we go. So we've got respectfully submitted here, Todd Blanche and John Lauro. Now, Lauro, Singer, Pavilon, out of the Lauro and Singer firm. So we've got two sets here. This one is PHV means pro hac vice, which means they were allowed to come in on this case, just for this case, as special counsel. I'm waiting for you can't handle the truth. Oh my gosh, I know. I'm just like, what day of constitutional law did these attorneys miss? I'm just thinking to myself, I'm like, was it halfway through? I mean, was there too much, party beverages consumed? What's happening? These are just basic constitutional law principles. Oh my gosh, it's just basic. I know. Oh, well, it's a lot. Yeah, it's a lot. Wish we were on the prosecution team. I thought, hey, if they've got an interesting argument, let's take a look and see what we can do to kind of offset their argument. But if they don't even have a valid argument, it's kind of like it's not as much fun, Yeah, it's a waste of the court time. Yeah, it's just not as much fun because, the law that they're using is incorrect. So I'm like, oh, that's like somebody not being able to play because, they didn't bring the game board. Like, how are we supposed to play if you don't even bring the board to play with? I'd hire the hell out of you. Oh, thank you so much. I don't know. If you brought up the Fitzgerald case, I might not be able to keep my cool. Oh my gosh, it drives me crazy. Oh my gosh, how do you think us accounting peeps feel about the worthless clause? Lisa, yes. Oh my gosh. Oh, the worthless clause. Oh my gosh. I aced. Well, yeah, Ray, go for it. I mean, come on, you know the law now. You know what it is. You get what you pay for. All right. Well, let's skip through this here, okay? So we've gone through this analysis such that it is bologna sandwiches here, blah, blah, blah. We'll move on because I just can't bring myself to go into that even more. So now, again, they're citing another irrelevant case. All right. So the executive privilege protecting presidential communications is also designed to protect the president's ability to function in his role to the maximum extent. It's fundamental to the operation of government, inextricably rooted in the separation of powers in the Constitution. So they're actually citing Nixon, but for the wrong reason. I'm like, all right. Oh my goodness. Oh my goodness gracious. Oh, it's driving me crazy. All right. Here we go. Moving on, everybody. Here's B. Impeachment and conviction by the Senate provide the exclusive method of proceeding against a president for crimes in office. All right. Well, let's take a look and see what their argument is. No bologna sandwiches involved. Like, proofread your stuff. Like, look up the law you're using. What are you doing? Oh my gosh. Oh, all right. Presidential immunity from criminal prosecution for official acts is also rooted in the text of the Constitution. The impeachment clause provides that the president may be charged by indictment only in cases where the president has been impeached and convicted by trial in the Senate. Here, President Trump was acquitted by the Senate for the same course of conduct. All right, so let me just grab my Constitution here. Hold on just a second. Let me grab it so I can read you the section that they're talking about. Just one moment. Okay. Let me just double check. here? So we've got, I just pulled my bigger Constitution here rather than my little book, just so everyone can see it better. So let's go to Article 1. I know you probably are all appalled at the state of my Constitution. Sorry, I use it so much, sometimes it gets out of line. All right, so let's look at Article 1 here. It's under the Section 3 for the Senate. Whoops, I've already lost track of the pages again. Hold on, everybody. Don't tell anybody, don't tell my constitutional law professor that this is the state of my Constitution right now, okay? All right. Here we go. So this is Article 1, Section 3. And we'll go down in here. Okay, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. So this section actually says that if you are pulled in for impeachment, you're still liable and subject to an indictment. So, okay. Yeah. So there's that. Okay. Everybody, we got it. Oh my gosh. They're citing the Constitution, the section that actually says that you can be indicted. Conviction's not required. It just says you may be subject to liability if you're convicted. That's what it says. Bologna sandwiches. Another incorrect citing. I know. Article 1 negates presidential immunity to some extent. I think that's a great way of putting it, BT. That's exactly right. Because with that language, it clearly states here, shall not extend. So Congress cannot do anything more than impeach, all right? So no further than removal from office. They can remove from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. So they'll say, hey, you've been impeached, and all we can do is remove you from office. They can't put you in jail, right? But the party convicted shall nevertheless be liable and subject to an indictment. So again, they could be removed, but also they could face punishment. So I think that's an excellent way of putting it, that presidential immunity does not extend, is not unlimited. Yep. Yeah, the law in this area is very robust. Actually, impeachment is mentioned multiple times in the articles in creating it. It seemed almost like they were, a bit obsessed really with this idea of impeachment. Yep, and here we are. All right. President Trump was acquitted by the Senate for the same course of conduct. So, that doesn't matter. All right. Impeachment clause of Article 1 provides judgment in cases of impeachment shall not extend further than removal from office, but the party convicted shall nevertheless be liable subject to indictment, right? Because the Constitution specifies that only the party convicted by trial in the Senate may be liable or subject to indictment, trial, judgment, or punishment. It presupposes that a president who is not convicted may not be subject to criminal prosecution. Okay. Now, this is the first argument. It's absolutely goes outside of the scope of law, but it's the first time I've seen them actually present a question. So they're saying because of the language in there that you can presuppose then that a conviction is required in order to go forward on an indictment, which is, of course, completely wrong. But, there you have it. People use old scriptures and disregard. Yeah, I know. Kristen, that's a great analogy. Absolutely. Yep. He does this to grift. Yes, he does. I just don't know when the court laughs it out. Yeah, I don't know. I saw an interesting analysis today of someone who was saying that they feel like in New York, in the New York civil case, he's pushing the judge to find him in contempt because the judge may then send him to jail. Because I did more research, and apparently you can do that in New York in a civil case. And he's pushing the judge to do that because if he gets sent to jail, it would help further his narrative that everything is corrupt and against him. I thought that was a very interesting analysis. I think that the analysis here, could be if the judge just throws this out, then, there's a question of presidential immunity and that, it's kind of stacked against him. Meanwhile, the law he's using is not correct. It's just not a correct analysis of the law. He's indicted 4 times. Yeah. Can you give us your unbiased opinion? Well, my unbiased opinion is that they're using the wrong law. And the reason why, you can ask those questions. I don't know. I've heard multiple reasons why. But the law that they're relying on is not correct. That is not a correct interpretation. This is the same thing that happened in his Trump v. Clinton case, in his CNN case. This is the same law that, way of using the law that the New York judge said was wrong and sanctioned his attorneys. He's like, you have no basis in law for these arguments. I keep telling you that, and you keep sending it. It's the same thing that's happening here. Yeah, out to get him. Right. I don't know what's going to happen. I don't know, but I thought it was an interesting analysis. I mean, I don't know if it's true or not, but I thought it was interesting. Who are the lawyers responsible? Well, these guys are the ones for this case in D.C., but, he's got different batches. In New York, he's got a set of 5 attorneys, and they were all sanctioned $7,500 each because all of their arguments had no basis in law, and they were told that. Now, I would say this argument has no basis in law either. It's a similar strategy. I do have the best mods. I do. All right. So, I don't know. That's interesting. So let's keep flipping here. Look, he's citing his own case. He's citing the dissent. Now, as we know, the dissent is not reliable in court, but he's saying here the removal from presidency, disqualification from other offices is a consequence that can come about only after the Senate judgment, not during or prior to the Senate trial. So we're quoting Alito. This was how Hamilton explained the impeachment provisions in the Federalist Papers. He wrote that a president may be impeached, tried, and upon conviction would afterwards be liable to prosecution and punishment in the ordinary course of law. And we're quoting the Federalist Paper. All right, so number 69, number 77. Also see Scalia and Garner reading interpretation of the legal texts. So we're getting, very esoteric here, but I still don't see how this is applicable in his case. All right, James Wilson and the Philadelphia Convention. So he's going all the way back. Okay, here's Clinton v. Jones, by the way. So we are citing Clinton v. Jones. So at least they know the case exists. That's good. The president is amenable to the laws in his private character as a citizen and in his public character by impeachment. There's more to the Clinton case than that. So they're just using the Clinton case to quote the Federalist debates? What? Oh my gosh. Here's another Federalist paper, another one here. So he's asking the judge to redo the entire doctrine of presidential immunity. I think that's what he's trying to do here. He's asking Judge Chutkan to change the doctrine of presidential immunity that was set with precedent in Nixon v. U.S. That's what he's asking. I don't think she's going to do this. I don't think she's going to do that. What's a Federalist paper? Okay, I'm so glad you asked. All right. So Federalist paper. Okay, let me take you back. I'll do the quick version of this, okay? So we had, right, they are not laws. You're absolutely right. We had the Articles of Confederation, all right? So let me just draw the path, all right? We had the Articles. Let me change from red. We had the Articles of Confederation, and they didn't work because we had no central government. So everything fell apart. People were starving. It was awful. All right. So they said we need to have another form of government. We need to fix it. So Madison and Hamilton wrote letters back and forth to each other talking about this idea of a central government and what powers and authorities the different branches of government were supposed to have. So they were creating the government. These letters that they wrote back to each other, they call the Federalist Papers, because it's discussing this idea of a federalist government or a central government. By the way, John Jay was involved, but he only wrote 5 of them, so he doesn't really count. These guys wrote hundreds. So that's what the Federalist Papers are. They are this discussion of a federal government plus a state government. So federalism discussion back and forth before Madison drafted the Constitution. So these papers were pre-Constitution. So, the comment's absolutely correct. They're not law. They were letters to each other debating the new government they were forming. So to cite them in a brief is basically saying, forget about what's actually written in the Constitution. Let's talk about letters that were written before the Constitution was ratified. So it's not an appropriate argument legally. Always wondered what the Federalist Papers were. Yeah. I mean, there's some discussion in the Hamilton musical about it, but it really was between Madison and Hamilton. Now, also, just as an FYI, John Jay, who got sick, that's why he only wrote 5 of them. He was the actual first Chief Justice of the first U.S. Supreme Court. Yep. Next to the Magna Carta. Oh my gosh. Okay, so back in 1214. No, I'm just kidding. I'm not gonna do that. All right, so let's just skim through some of the rest of this. Bologna sandwiches. Let's see. Let's see what other cases we're citing. We've got Fitzgerald again. We have Marbury versus Madison, which was the case that established judicial review all the way back in the way back beginning in 1803. So we're citing that. This is the Constitution article regarding impeachment here. You just made that up. No, I did not. What year was the Magna Carta? Let me double check. Magna Carta. It was 1215. Did I say 1214? It was 1215. All right. So we go here. We've got early authorities supporting presidential immunity from criminal prosecution. We're going to Marbury versus Madison, which is not relevant. Here, I'm not going to go into that because, again, I don't think it's necessarily relevant. Next, we've got 234 years of history and tradition supporting presidential immunity from criminal prosecution. And what are we supporting that with? We're supporting it with Nixon v. Fitzgerald, which isn't necessarily that good of a case here, as we've talked about. Historical practice for not exercising. Again, I'm skipping through this because these arguments are, the Prince case, that's interesting. The constitutional practice tends to negate the existence of the power asserted here. I don't know about that. So, E, analogous immunity doctrines support presidential immunity from criminal prosecution. Now let's see what support they have. Again, they're relying on Nixon v. Fitzgerald. The other thing is, too, when we're doing legal writing and when I'm teaching legal writing, is you cannot rely on one case for your entire argument. It doesn't work that way. And I think they're overusing this one particular case because what happens is if your interpretation of that case is wrong, your entire brief is going to be bad. Is no one checking their work? Great question. I don't know. I don't know. Oh my gosh. All right. So here we go. I'm just looking through what cases they're citing here, checking them. Absolute judicial immunity, which is completely wrong. So like absolute executive immunity, absolute judicial immunity protects state and federal judges from criminal prosecution as well as civil lawsuits based on their official judicial acts. That is not the correct stating of that. You can, even if you do an official act or within the scope of your official employment, if it's an illegal act, you can be charged with it. They find new employment after one page. Yes. So, judicial immunity, including immunity from criminal prosecution. If you do an illegal act as a judge, you can be prosecuted. So this, I would think, is a misstatement of the law here. In accordance with this long common law tradition, our courts have universally rejected criminal charges against judges for their judicial acts. Well, for their judicial acts, but if their judicial act is illegal, they can be charged with that. So I think, again, that's another misstatement of the law. So we'll keep moving on here. We're going to plow through this. Concerns of public policy favor the president's immunity from prosecution. The presidency involves especially sensitive duties. Again, this is the Fitzgerald case, but this was all argued out in the Nixon case and already decided unanimously. Requires bold and unhesitating action. And the U.S. Supreme Court has said yes, but not illegal action. That was very clear as well. This is the Barr case. I'm skipping through again because their legal arguments are just not correct. For the reasons Supreme Court emphasizes in exercising the function of office, the head of the executive department, keeping within the limits of his authority, should not be under an apprehension that the motives that control his official conduct may at any time become the subject of inquiry in a civil suit for damages. I don't know about that. Sticky note, yes, sorry everybody. I'm glad you reminded me. Here we go. So Supreme Court emphasized function of the office, the head of the executive department, right. It would seriously cripple the proper, again, Fitzgerald, I was going to say that's actually contradicting the Clinton v. Jones holding. So I would say that is an incorrect analysis as well. Yeah, baloney repeat. Focus should not be blurred. That's incorrect. Quoting again Fitzgerald. Wow. And then quoting the Vance case. He's citing the dissenting opinion, which is not law that is setting precedent. Without immunity, the president would be harassed by vexatious actions. Another key purpose of immunity for officials is to prevent them from being harassed. True. But you still can't commit crimes. All right, number 2, the indictment alleges only acts committed within the core of the president's official responsibilities. Okay, everybody, we've turned the page. His next argument is that the actions that were done, according to the indictment, were within the scope of his duties as president. All right, so we're switching course now. So now we're not talking about changing the entire doctrine of presidential immunity. Now we're talking about whether or not what he did was within the scope of his duties as president. All right, so could you score this as if it were a student's paper? well, I suppose I could. Oh, I don't know. So far what I've read would be, I would write a wrong analysis on it. Oh, this is where I would be. So I would write redo and see me. Honestly, if this was a student's paper, oh, that's exactly what I would write. Sedition. Well, right. It's really not. Yeah, it's really not. All right. The grades don't go that low. That's true. Oh, all right. Okay. So let's go through this. Let's go through his rationale, explaining why he believes then that he was acting under the authority of his position for doing what he was doing. All right. Indictments based entirely on alleged actions within the heartland of President Trump's official duties, or at the very least, the outer perimeter. All right. So now we've got a complete, these are incorrect. Was it the heartland or was it the outer perimeter? These standards are vastly different of his official duties. As President Trump is absolutely immune from criminal prosecution for such acts, the court should dismiss the indictment. And I am looking at this like I would a student paper. This is how I would grade it. That is false. Recheck the law. That is incorrect. The scope of criminal immunity includes all actions that fall within the outer perimeter of the president's official duties. The Supreme Court adopted the expansive outer perimeter test for immunity. Precisely, any functional test would be inconsistent with the broad scope of presidential duties. It at 756. All right, so that's an incorrect citation. All right, according to amicus brief, this is not proper authority. Oh my gosh. Here, all right, this immunity, the Supreme Court's explained, may not be curtailed by attempting to parse discrete presidential functions or through allegations that official acts were taken with improper motives, because the president has discretionary responsibilities. In many senses, it would be difficult to determine which of the president's innumerable functions encompass a particular action, quoting Fitzgerald. All right, this is another improper citation. Here. In other words, the outer perimeter of presidential duties and thus the scope of presidential immunity encircles a vast swath of territory, because the scope of the president's duty and authority in our constitutional system is uniquely and extraordinarily broad. Article 2 makes a single president responsible for the actions of the executive branch. All right, so, okay. And the president's the only person alone. All right, so, all right. This is a sloppy citation. Here is what I would call this. We're quoting a case on top of another case in the concurring in the judgment, which again is not improperly cited. So I would take points for that. Among these Article 2 duties, perhaps most fundamental are the framers' dual mandates that we hold the executive power, and with it the duty to take care of the laws be faithfully executed. Citation here. To this end, the president must assume supervisory or policy responsibilities of utmost discretion and sensitivity, which include the enforcement of federal law. We've got the Fitzgerald case again, and also Vance. Quoting the president's duties, which range from faithfully executing the laws in the armed forces. So this is just repetitive. Here, I would take off for that. Additionally, the public looks at the president as a leader for the nation for guidance, reassurance, over which the executive branch of federal government as a whole has no direct control. From the actions of Congress and the judiciary to the policies of the state and local governments, the conduct of private corporations and individuals, the president can and must engage with the public on matters of public concern. So I would X this out and say irrelevant here. And again, improper source here. All right. Thus, even where the president's actions are directed towards the constitutional responsibilities of another branch of government or concerns matters for which the president himself bears no direct constitutional or statutory responsibility. Again, this is another improper citation. His actions are often still within the outer perimeter of his official duties. See Fitzgerald. So that is also not good. That's not very good. Oh my gosh, it's so bad, everybody. This is really bad. Oh, yikes. Without question, the president occupies a unique office with powers and responsibilities so vast and important that the public interest demands that he devote his undivided time and attention to his public duties. We're citing the Clinton case. I would ask again, what's the relevance here? As the Supreme Court held, the higher the post, the broader the range of responsibilities and duties, and the wider the scope of discretion it entails. As the highest of all posts, the presidency warrants the broadest possible immunity, and acts must fall within the outer perimeter unless clearly established. Okay, so what is your point? Here, what's your point? And I would also say bad citation here as well. Okay, so here we go. Oh my gosh. I don't think he'd dictate. No, he wouldn't know any of these words. It sounds like, some intern threw a bunch of stuff together. The nature of the act, not the manner in which it was conducted or its alleged purpose, determines whether it falls within the scope of immunity. I would say here there's no authority for that conclusion. You can't just make conclusions. You have to actually have a legal argument. In deciding, apply an objective test based on the nature of the act. I would say here, where's your source? Cite your source for your test that you're talking about. It's not overcome by allegations of bad faith or malice. This is not supportive law here. Chord here, inquiry again. So this is not supporting that premise. They're just making conclusions. Repeatedly emphasize this point. Again, in the Fitzgerald case. Fisher here. Learned hands, often cited analysis. Relevance again here. Improper citation. And nor does a mere allegation that an act was unlawful or otherwise inconsistent with a particular statutory scheme place it beyond the outer perimeter of the president's official responsibility. For example, in Fitzgerald, the plaintiff, a federal employee working for the Air Force, argued President Nixon exceeded his official responsibilities in unlawfully causing the plaintiff's dismissal without adherence to certain statutory processes and protections. Because Congress had granted this legislative protection, no federal official could, within the outer perimeter of his duties of office, cause Fitzgerald to be dismissed. So, how does this support your argument? Because it doesn't. The Supreme Court rejected this argument, holding President Nixon's general constitutional statutory authority to oversee the Air Force placed the nature of his acts comfortably within the outer perimeter of his official conduct. And there's no support, again, for this statement. We haven't built that argument up well enough to be able to use it yet. Supreme Court determined, blah, 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 blah. For the same reasons, alleging immune acts were part of a conspiracy does not defeat immunity. Such absolute immunity spares the official any scrutiny of his motives, and an allegation that an act was done pursuant to a conspiracy has no greater effect than an allegation that was done in bad faith, malice. So this one is out of order. So this is an organizational issue. Needs work. See me. Does the prosecutor get an opportunity to respond before the judge decides? Yes, they do. They do. I mean, this brief, again, I just don't, I can't keep going through and marking this up, everybody. It's just too much. It's too much. But what happens here is the prosecutor will go through. This brief is, let's take a look. Let's take a look and see. 46 pages long. All right. 46 pages of incorrectly cited law, bad arguments. Hydrate. Oh my goodness. Oh my gosh. 46 pages of this, which is, no, you're not supposed to do that. This is like this. No. So the prosecutor will go through, again, Jack Smith, and say, you're citing incorrect law. Your arguments have no basis in law. Your authority is incorrect. There is no argument. They're just quoting old cases, the Federalist Papers. They're quoting the Constitution over and over and over again. Like, we know what the Constitution says, people. And they're citing books and op-ed pieces in a formal brief. Oh my gosh. No. Meeting with state officials about the administration of a federal election lies at the heart of presidential official duties. It's irrelevant. And the reliance on the Fitzgerald case just over and over and over again, it just seems like they didn't go to law school. And they're making a citation quoting a case. So they know the Clinton case is important, but they're not using the holding in the Clinton case, which is fascinating, actually. I think it's very interesting. They're citing Clinton v. Jones, which overruled essentially Fitzgerald, but they're not using the holding in Clinton v. Jones. They're just quoting random bits out of the case. And that they're quoting quotes out of the case. Like, what are you doing? I don't. What's a holding? Okay, sorry. All right, so whenever we have a case, the U.S. Supreme Court, the key to the case is the decision that they made. In Clinton v. Jones, the question was, could a sitting president be sued? Was he immune to being sued? The holding in the case was, no, he was not immune. He could be sued. They could go forward on a case, even though he was a sitting president. That was the holding. So what the U.S. Supreme Court decided is the holding of the case. This is how you lose a case. Yes! Do you think they used citation? Oh, it could be. It could be because the citations that they're using here are really odd looking. Like, again, like I was saying earlier, they're quoting free enter fund quote. So they're quoting this out of this case, which was quoted out of the Clinton case. Like, their citations are weird. So, and then why would they use concurring in the judgment? But if he's concurring in the judgment, are they quoting a dissenting opinion then? Like, their citations are very odd. Are they trying to lose? I don't know. The citation's weird. I would say it's possible that AI could have done it. It's possible. I don't know how else to explain this. Like, what is this? This isn't even a proper citation. Like, that's just not even correct at all. Id at 78, like, this right here, you would lose. I would dock points here. 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 This is also incorrect. Just basic legal writing 101 is incorrect. Have you ever seen a case argued so ineptly ever? No. No, I have not. I have not. Oh my gosh. Yeah. I mean, and it's not even together. I mean, their stuff isn't even thrown together. It's like thrown not together. All right. Here we go. We're coming down to the final pieces. Communicating with the president of the Senate and other members of Congress about the exercise of their official duties lies at the heart of the presidential's official duties. So I don't know. I mean, so this is where he's talking to the vice president. Constitution assigns the president extensive roles in the legislative process. Why are we citing the Constitution for that? And we're citing the Constitution again for that. Here's another citation of the Constitution. And then we're idding the Constitution. Whoa. This right here, this would be 10 points. I would knock 10 points off for idding the Constitution in this situation. I would. Probably because I'm frustrated. That's probably why. It's not even thrown together. Well, yeah. I mean, it's not even together. It's, oh my gosh, this is awful. This is awful. Again, this is incorrect citations here. Just the basics. Quoting as well. All right, hold on, everybody. I've got to get my power pack plugged in real quick. I can't leave us just hanging like this, so I need to finish. We've only got 2 pages left. So give me 1 second here. I gotta reload my battery. Sticky note. Yes. Where did my sticky note go? Where did it go? I'm so flustered by the level of madness here. All right. Hold on. Oh my gosh. Oh man. What does idding mean? Okay, sure. So, I'm sorry, everybody. So when we do a citation, when we cite something, if we are, hold on 1 second, this might pause while I plug in this pack. All right, I'm back. All right, so when we do a citation, if we're using the same citation throughout the page, at the end of each thing, we would put id, and id just means the exact right above it, the previous citation in the previous sentence. So that's what we do for idding. So you have to be careful with idding to make sure that it's following your citations properly. So it's, yeah, like ditto, right? Because if we were to write the same exact case citation every single time, I wish I could show you. I'm looking on here, but there's nothing in here that's proper. So I can't show you. Oh my gosh. Oh, it's so bad. Hold on, let me see if there's something in the indictment. Oh my gosh. Ugh. All right, hold on. No, I don't see anything in here either. So let me give you an example, all right? So we'll just say after this citation here, right? So here's the Nixon v. Fitzgerald. So next I'm writing a sentence, I'm writing another sentence. Now I'm using this citation, but I'm using page 750. So I would say id at 750 to show my citation. Now I write 3 more sentences, but I'm using the exact same page. So I would just write id because I'm using page 750. Okay, does that give you a little bit of an example? Yeah, they're idding using different citations. Yeah, the citations are bad. They're bad citations. Yikes. Where's your mood ring? I need one. I need one right now. Oh my goodness. All right. Let me get us through the end. The continuation of the same page cited. Yes, exactly. So you would use id to refer to the previous citation and then add the page number. But if the page number is the same, then you don't need to add the page number, right? So for example, again, this is not proper here. So yeah, I can't even pull it out of here. It's not even done correctly. I'm so frustrated. All right, hold on. We will move on to the next page. Here we go. What are we citing here? U.S. House C-28, the papers of Ulysses S. Grant? What? Oh my gosh. Are you kidding me? Are you seriously kidding me? What is happening? Oh my gosh. What is this? So crazy. I can't. I'm shocked. All right. Pull myself together here. Pull myself together. Oh my gosh. All right, so let's quote Ulysses S. Grant papers because somehow that's relevant here, and we're quoting Scholars Junction. What is happening? I just all right. Okay. Number 5, allegedly organizing contingent slates of electors falls within the president's official duties. All right, well, let's take a look at this because this isn't a thing. So let's take a look. The indictment alleges President Trump directed or approved of other individuals to organize contingent slates of electors. The indictment clearly alleges these actions were part and parcel to President Trump's alleged attempts to convince, thank you for the likes, everybody, to convince the vice president and members of Congress to exercise their official authority. All right, well, you've already quoted that. So what's your point? So this is just a direct quote of the indictment again, and we're restating it. The contingent electors' roles the indictment alleges was to allow President Trump to convince the vice president and other members of Congress. Like you've already said this. So this is a repeat. And again, we're quoting the thing again. Where's the argument? Where's the argument? This is all just repetition of what the language was in the first part of their brief. These actions fall within the presidential's official responsibilities for 2 reasons. Okay, here we go. Yeah, let's take a look at the reasons. First, As noted above, the outer perimeter of the presidential's official responsibilities includes the rights, duties, and obligations growing out of the Constitution itself and all the protection implied by the nature and government under the Constitution. The Constitution explicitly provides for presidential electors and delineates their role. What are you even saying? This is ridiculous. While presidential electors are not officers or agents of the federal government, they exercise federal functions under and discharge of duties in virtue of authority. How is this supporting the use of fake electors? Indeed, the indictment itself describes the selection of presidential electors as an integral part. Yes, but not fake ones. Only the real ones are an integral part. I don't get that analysis. Organizing slates of electors, therefore, relates directly to the rights and duties. All right, so there's an admission. And thus to the president's responsibility. Without contingent slates of electives, there would be no alternate option for the vice president. Whoa, here we go. Whoa. All right, this is very interesting. Here we go. All right, so this is going to be their legal argument for the fake electors. Without contingent slates of electors, there would be no alternate option for the vice president to certify, rendering futile the president's entirely legitimate efforts to urge Congress and the states to reconsider evidence of fraud and irregularities. Wow. Organization of the slates of electors, in other words, advances two presidential functions, protecting the integrity of the federal election and urging members of Congress to act in a manner consistent with the president's view of the public view. Oh my gosh. Oh my gosh. All right. So he's justifying having fake electors because he said you needed to have them, so the vice president had a second option. So in order to give the vice president another option rather than the valid electors, you had to have this alternative slate of electors, which is not a thing. That nowhere is there a thing that allows for that. And he's saying that the reason is because he, as the president, had deemed this was necessary for the public good. So he made literally the executive decision that they needed a second slate of electors for the public good because of whatever reasons. So it was fine for him to choose or have people choose fake electors to show up and influence the vice president. Wow. Wow, that's a lot. That's a lot, everybody. That's a lot. Yeah, it was necessary for the public good. That's a lot. That's a lot. I actually thought this would be a valid argument. Yeah, it's a lot. Thus, these actions clearly lie within the outer perimeter of the presidential's official responsibilities. So, again, he's saying he wants Congress to conduct itself in a manner consistent with the president's view of the public good. That's not how democracy works at all. That's really scary. It took 50 pages for them to get to the point. Oh my gosh, it's so true. It's so true. Yeah, he's trying to override Congress because of his own view. So he's saying because he was president, his view of what was best, he, was like, yeah, we need these alternates. Yeah, that's exactly what, yeah. He's admitting to wanting, well, pretty much, yeah. I would say this is a pretty significant paragraph here. All right, second, as the indictment itself emphasizes, the actions of organizing slates of electors were ancillary and preparatory to the acts of communicating with the vice president and other members of Congress and urging them to exercise their official responsibilities a certain way. Whoa, what is this? What is this theme that they're using? That's interesting. Consistent with the president's view, a certain way, which are themselves core exercises of presidential responsibility. Wow. I don't know. This one's pretty bad too. Organizing slates. were needed in order to communicate. So he said they needed to get the fake electors in order to talk to the vice president, is what this analysis says. Yeah, that's a lot. Ignoring the voters in favor of what he wanted. I think that's exactly what he's saying here. That's exactly what he's saying. He's saying he needed to talk to the vice president, and because of that, it was okay to have fake electors. Yeah, he admitted it. Yep, he just admitted it. That's pretty huge admissions. But he doesn't see anything wrong with it, which again is kind of the ongoing theme to these cases, is that there doesn't seem to be anything wrong with it. Acts that are intertwined with immune actions are themselves immune from liability, for example, blah, 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 blah. So I'm not going to spend time on that. So he's justifying using bad case law here. All right. Ooh, let's back up to this footnote. Let's back up. Nor were such actions unprecedented, quite the opposite. At the time of the alleged conduct, the Electoral Count Act did not prohibit organizing contingent slates of electors, and such electors had been organized previously in the disputed elections of 1876 and 1960. Okay, all right, so this is where that legal argument that kind of gave form to the fake electors. This was that Nixon issue out of Hawaii that they talked about, and then also this 1876 election as well, which both of these situations were nothing like what was happening in 2020, including the former case with the support of the sitting president. This was thus not a situation where the president takes measures incompatible with the express or implied will of Congress, but a situation where the president was acting in the area of independent presidential responsibility. So let's take a moment and highlight this. So this whole issue where the president is trying to override Congress, they just quoted that. And then they said, no, we're not trying to do that. We're acting in the area as an independent president. And they're citing the Youngstown sheet and tube case, which I have done a brief on. So yeah, I think that's interesting. Like, we're not overriding Congress. I'm just doing what I'm supposed to do as a president. I've never seen a more ridiculous argument. All right. And I've read a lot. I've read a lot. I read the Twinkie defense. All right. That's ridiculous. All right. That's my legal opinion. Yeah, I agree. It's a lot, everybody. It's a lot. Electors have nothing to do with electors. I think that's genius. Exactly. Oh, all right. Here we go. So, citing whatever. The Supreme Court has recognized that some duties prior to the initiation of prosecution are also protected. Preparing to initiate a prosecution may necessitate obtaining, reviewing, and evaluating evidence. Absolute immunity may attach. That's incorrect. So to hear President Trump's alleged acts regarding the contingent slate of electors performed within the continuum of other immune acts, such as communicating with Congress, are also immune. So his rationale is completely not based in law whatsoever. For these reasons, the acts alleged in the indictment lie firmly within the outer perimeter of the presidential's official responsibility. Therefore, they cannot form the basis of criminal charges against President Trump. We'll hit that in a minute. The court should dismiss the case. So let's bump down. The indictment also alleges President Trump filed lawsuits challenging the election outcome, right? Yet the indictment proclaims that it did not directly relying on such actions, that it is not directly relying, all right, admitting that President Trump was also entitled to formally challenge the results of the election through lawful and appropriate means, such as by seeking recounts or audits. With the wisdom teeth saying, yeah, this is real life. Yes, I agree. I'm with you on that. So within the indictment, Jack Smith wrote, look, there are legal roads for you to challenge the election, but the road you chose was not legal. So that's what they're quoting here. Emphasis added, accordingly, these are included only as acts in furtherance of the supposed conspiracy, which are immune from prosecution for the reasons just said, regardless of whether such lawsuits were filed in a personal or official capacity. Moreover, the act of filing lawsuits alone without more is manifestly insufficient to support any charge in the indictment. All right, so because what he was saying is you lost all of your court cases, and so the only thing you could think to do would be to interrupt Congress certifying those electors. That's what the point was in the indictment with this language. Yeah, so there you have it, everybody. There you have it. We made it somehow, limping to the finish line, limping away to the finish line. Oh my gosh, this was awful. This was really bad. I thought the Giuliani defamation was bad. No, that's good. That was a good one compared to this. Oh my gosh. Right? If you lost as an adult, you accept it. Did we make it? We made it, Ava. We made it. Are they going for the pity verdict? I don't know. I'm just like, I cannot even. I'm shocked. My brain is not completely understanding what happened here by competent attorneys. Like, I think it's very possible that this was written by AI. Very possible. I think that's a great premise. So much baloney. Yeah, I mean, and it's like bad baloney too. It's not even like edible baloney. You can hear the Twilight Zone music. This was bad, everybody. This was bad. And, you know, even if they had anything in here that would have been usable, I would have said, all right, well, good luck with that. But no, this is, Joey's going to win, right? Well, I mean, you would have to undo, 275 years of law in order to do that. The fact that there's 45 pages, I know AI would do a better job. Oh my gosh. I agree. Yes, sarcasm emoji is really essential. Attorney was in the same room where it was written. Yeah, I mean, I'm shocked. I am shocked. I am just shocked. I cannot even, I mean, again, where he's setting out literally, like, I'm not trying to negatively affect Congress, but you should take my view because it's in everybody's best interest. Like, he's a parent that's in charge of everything, because I said so. That's not a valid legal argument. Not because you said so. You're not going to win that argument. Are you annoyed as an attorney? Yes, I am. I'm annoyed and I'm offended. Quite frankly, I'm offended because it makes the rest of us look really crappy. If attorneys can file stuff like this and get away with trying to make these arguments like this, it's offensive. It's offensive. I mean, it's bad writing, it's poor citations, and it's legal arguments with no basis in the law. And that makes it a non-legal argument. There's no argument. It's just baloney. It's a lot of baloney. It's a lot. Yeah, it's a lot. I just got here. What are we talking about? Sticky note. Here we go. Oh my gosh. I don't know who has, the leading attorney is supposed to look at this stuff before they file it. I know that they filed stuff and made mistakes and then refiled it. So you can refile if you screw up. That's perfectly normal. But I think they actually meant to file this. I think they meant it. They literally meant this. And that is just so deeply disturbing. How long will we have to wait for Jack's response? Great question. That's a great question. So let me pull up what I've got here for the docket that came with this. So there were a few more things that were filed after this. All right, so this was filed on the 5th. The next filings then, we have just a couple of things we had, and I'm not going to read these because it's just too painful at this point. It's too painful, everybody. We do have a reply in support of a motion for access, right? So we had this hearing question. Again, this is the DC case. That was filed. We had also the reply in support of a motion for extension of time So we had this ongoing discussion, and Jack had said, look, you don't need extra time. What are you talking about? And then on October 6th, right, we've got the opinion and order sent down by Judge Chutkin. So we had this question again about the conference and setting time. So let me just take you through what she held. For the reasons stated above, defendant's motion for access adjournment for the SIPA deadline is hereby granted in part and denied in part. The court will not require the government to publicly docket a partially redacted version of the SIPA for submission, which is a classified document requirement. The defense may file a brief objecting to the ex parte nature of the government's SIPA, and by October 11th, so let's add that to our calendar real quick. All right, so we gotta stay on top of everything here somehow. All right, so we've got October 11th, DC SIPA objection due. We'll just keep that going. And the government may file a response to that brief by October 18th. So DC government response here. The deadline for defense's SIPA 5 notice remains October 26th, which is normal, but defense may file supplements. Likewise, defendant's motion for an extension of time is hereby granted in part and denied in part. So let's see what we have. Court's pretrial order is amended as follows with respect to pretrial motions, deadline set forth in the second paragraph. Off to bed. Yes. Oh, the headache. No. Have a cup of tea. Oh my gosh. It's amended as follows. So Rule 17C motions to compel shall be filed by November 9th. So let's look and see what we had before. Motions to compel. So it looks like she's only moved it a little bit. The motions to compel for November 9th. And those motions shall be filed in opposition on the 24th. So I think that that's not too much, actually. So DC motions, I'll just add this on here. I'll give you an updated version at some point here. Response in DC is due. All right. Response due in DC, and replies in support of those motions shall be filed by December 1st. If there are multiple such motions, then the extent possible motions, oppositions, and replies shall be filed in omnibus. All other pretrial motions, including motions to dismiss and other dispositive motions, like excluding motions in limine, in the paragraph of the pretrial order, shall be filed by October 23rd. So let's take a look again. So here we had, let me just clarify, she's just shifting the dates around a little bit. We had oppositions to motions due on the 23rd. And so she's saying here that excluding motions in limine, suppressions motions, they shall be filed by October 23rd. So she's just moved the days just a little bit. So let me summarize here, all right? We've only got a few days difference, and replies are supposed to be done within 10 days. So they asked for this huge extension. I believe they actually asked for 3 months, if I remember correctly, from Jack's motion, and she moved it a few days, is my understanding. Now, I'll go back through and be more thorough with that because I haven't spent too much time on it, but it looks like it's not been moved that much. Something he can appeal to the Supreme Court. Anything's appealable, and it is federal law, so technically the U.S. Supreme Court is the final decision on federal law, but I don't have any brain cells left. Okay. Okay. We should do closing statements, everybody. Here we got to do closing statements. Oh my gosh. Okay. So what have we learned? We've learned Rudy Giuliani in his defamation case has no basis in law in New Hampshire, right? We know that the motion to dismiss has no basis in law in constitutional law, so that's fine as well.
We do have then, let's take a look at the schedule of what I've got set. So we do need to do a Florida update. We've had some questions about movement in Florida too. We had a motion for a continuance, a motion for dismissal. I will do the Florida update then tomorrow. I'll be back on to do that. Also, a brief Georgia update I'll probably do on Sunday then. Okay, so I will be doing Florida because we've just talked about DC and New York today. We haven't really talked about Georgia and Florida, which are coming up. So I will go into that this weekend. We'll do Florida Saturday and then Georgia on Sunday. So let me just add that on here. Do an update as well here. Then again, we will probably, I may or may not do the civil trial review on the 9th. We'll see what happens. We'll see. I may need a break on Monday. We'll see how my voice is. But the 9th will be a question mark. But then on the 10th, I'll be back for the New York criminal case. I'll go through those felonies. One more break as well, and then back to Florida again. And then Fridays, I'm planning to start doing a weekly review of all of the cases. So today I wanted to get through the motion in Giuliani's case, but the Fridays in the future, I will just do kind of a recap of what's going on with all the cases in the future. Okay, so that's kind of my goal for the next few days. I hope everybody will be able to join me again. Health break for a month after this. I know. Oh, yes, everybody. Yes, everybody will need a break. So that's it for me for tonight, everybody. It is an ambitious schedule, but I think it's doable. I think we will be okay. But I think Monday, I'll probably take Monday off, but I am planning to come back on. Now, this 6 o'clock time, Central Time, really works best for my schedule because of, work and family and stuff. So 6 o'clock Central Time, I had gone live this morning. Were some of you able to join me this morning? Did that morning time work out okay? That 10 o'clock? Because what I might do then, I have a couple of extra. Yes, it did. Okay. I might do just for the next couple days. I still have a couple more things I wanted to go through that are not actually involving Trump. So I may do another live in the morning. Probably, I don't know, maybe Saturday or Sunday. We'll see. But I probably will just do one morning this over the weekend. I'm not sure which one. So turn on your notifications. If I do go, it would be 10 o'clock Central Time. So if I'm not on at 10 o'clock Central Time, then it's just not going to work out. And it just depends on how my voice is in the morning. So I will definitely be back at 6 Central Time, both Saturday and Sunday, but we'll try to get a morning in on one of those days to try to get through a couple more things real quick. So, oh, excellent. Wonderful. Sip hot tea. Yes. Is my voice getting really rough? I can't even tell anymore when it starts to get rough. Oh my gosh. Yes. Well, yes. And thank you everybody for joining me. Too early. Okay. Yes. Everything will be up on my YouTube channel. I am trying to make sure I get those up as quick as possible. I can post only one a day on YouTube. So I'm trying to do that. Yeah. The morning ones may not work for several people. So I'm really only going to do the morning ones probably once or twice a week. But morning was great. Yeah. So I think, I will do a morning one just a couple times a week, but I will also be here at my normal time, 6 o'clock Central Time. Well, good night, Vicky. Good to see you. Yes. Make sure, you've got the, notifications on and then just check back at 6 o'clock Central Time. I will be on. That's the best time for me. Any later than that, actually, I feel like I can't quite get all the material out to everybody that I want to talk about. So 6 o'clock Central works best for me, and I will try to pop on in the morning a couple times a week. So yes, thank you so much, everyone, for joining me tonight. It's been fun. We've all learned and struggled together. Oh, yes, Alan, good to see you. Thank you for coming, everybody. Thank you. Yes.
Have a wonderful night, everybody. And yes, look at all those likes. Oh my gosh. Thank you, everybody. Thank you so much for coming by. I appreciate it. So, when's the test? No test, no test. Yes, have a good night, everybody. I'll go ahead and sign off now and get some hot tea. But take care. Thank you again for coming and hanging out with me. I appreciate it. And I will be back again tomorrow. So reading it was the test. I agree. Oh my gosh, I agree. Yep. Have a good night, everyone. Take care.